May please, proceed with the consent of the counsel of the respondent. I beg to mention item number 16, Lord.
Item number 16.
Yes, Lord. In this case, I am led by Senior Advocate Ken Chaudhary, Lord. He has
Yeah.
some personal difficulties out of station.
Okay,
Maybe taken up a view with this.
okay. On request of Mr. Sikal, learned counsel for the petition, you have informed us, right?
Yes, so I have taken consent from.
With the consent of the learned counsel for the respondent. Para, brief the case on so and so date.
2404.
Lord.
May I please your lordship, with the consent of the petitioner, I beg to mention item number 22. Lordship, this matter is led by my senior Ken Chaudhary. Due to some personal problem, he is not able to come, lordship.
Roy
So-
Chaudhary is available.
My lord, only issue is this because tender was given to me, then on their complaint it was cancelled. My lord, there is a difficulty, let it fix on 24th March. my lord. 24th
No,
March.
24th. No,
25th.
25th.
My lord.
Okay, Miss R. Kakoti, learned counsel for the
Respondent number 8.
respondent number 8 has made a prayer for adjournment on the ground of difficulty on the part of Mr. Ken Chaudhary, learned senior counsel. Also, Mr. P.K. Rai Chaudhary, learned counsel for the petitioner and government advocate, learned government advocate for the respondents. State respondents are present. In view of, as agreed, sought for and agreed to by the learned counsel for the parties, lays the case on so and so.
2503.
May I please, your lordship, with the consent of others, I beg to mention item number 34. Here I am
Yes,
awaiting instruction, lordship. I require 3.
wait for the petitioner.
Lordship, I have taken consent, lordship. As Bothakur, lordship.
Okay. Mr. S.S. Roy, learned central government counsel for the respondents, has submitted that he is yet to receive the necessary instructions to file the counter affidavit and has thus sought for further 3 weeks' time
Lordship.
to file the counter affidavit. He stated that consent has been taken from the learned counsel for the petition to make the prayer. Because of the prior law, leave the case on science.
May I please, your lordship? My lord, I beg to mention for listing of a motion item, my lord. Today itself, my lord, the urgency is that, my lord, I am a, my lord, operating a livestock business of transporting buffaloes, my lord. While I am transporting 17 numbers of buffaloes, my lord, from Dimapur to Gauhati, Gosala, my lord, it had been unauthorizedly intercepted at Khotkoti area, my lord, Khotkoti police station, and it had been without any, my lord, seizure list, no documentation. Now they are taking custody of those properties. Even my drivers and mans are also missing.
Tomorrow.
My lord, my lord. Obliged.
May I, your lordship, lordship, with the consent of the other side, may I beg to mention item number 24 of today's list. Lordship, in this matter, there have been some subsequent developments which I need to bring on record. 24, 24, lordship. I've taken the consent of the other.
You are for the petitioner?
Yes, lordship.
Okay, how much time you need?
Lordship, 2 weeks' time, lordship. Let it be on 20.
Mr. M. Das, learned counsel appearing for the petitioner, has submitted that in view of subsequent developments, the subsequent events are in view of subsequent events. The subsequent events are to be brought, are required to be brought on record by way of an additional affidavit. He has thus sought for listing of the case after 2 weeks in order to file the additional affidavit. Post of
Lordship, can it be on 25th? lordship?
consent. Lays the case. Side you go. Consent.
Obliged, lordship.
May I please, your lordship? Lordship, I have with the consent of the other side, I'll have to mention item 46, your lordship. I am for the respondent number 1, your lordship. 2 weeks' time may be allowed to file our affidavit in opposition, your lordship.
46.
Yes, your lordship.
Okay, you have the informed the other side.
Yes, therefore.
Lordship, I am for the petitioner, Lordship.
Okay, Miss
Miss B. Sharma.
B. Sharma, learned counsel for the petition is present. Mr. P.K.
Bora, your lordship.
Bora,
On behalf of P. Bora, lordship.
on behalf of learned counsel, on behalf of Mr. P.
Lordship,
Burua,
is similar.
learned counsel for the respondent number
1, your lordship.
1 has prayed for and is granted 2 weeks' time to file counter affidavit on behalf of the state respondents. Post of lays the case on switch.
Lordship, a similar matter has been fixed on 27th March, Lordship, if it is possible.
27.
Obliged.
Obliged.
Lordship, I'm praying for moving an unlisted motion today, Your Lordship.
What is
Regarding Lordship remembers about a week back, Lordship, we moved the petition regarding the installation of CCTV cameras for the election, Your Lordship, for the state elections, Lordship. So what has happened in the meantime, Lordship, the technical bids were open, Lordship, were rejected on the same ground which were challenged, Lordship. So we have moved want to move a petition. That item is listed today, Lordship, item number 36. So I'm able
Okay,
to,
if time permits.
Lordship.
May I please, my lord? My lord, I have already circulated the adjournment slip yesterday regarding item number 33, Lord.
33.
My lord.
You are for
I am for the petition.
petitioner?
Yes.
Mr. M. Jamal,
My lord.
learned counsel for the petitioner has paid for listing of the case after how much time?
2 weeks time, Lord.
2 weeks time, after 2 weeks. Post of a mention memo to that effect has also been circulated yesterday. Post of the case that's adjourned for 2 weeks, leave the case on sales.
May it please
Yeah.
your lordship, I beg to mention item number 31. Lordship, the tender which was challenged in this petition has been cancelled. Thus, the petition stands infructuous.
Okay,
Lordship may kindly be pleased to grant liberty to withdraw the present.
okay,
Lordship,
Miss, your name please?
U. Bihani.
You Bihani, learned counsel appearing for the petitioner has submitted that in view of cancellation of the tender notice, assailing in the writ petition, the subject matter of the writ petition has become infructuous. And therefore, the petitioner pays for withdrawal of the writ petition. Full stop. Anybody APDCL? Mr. KP Pathak, standing counsel, APDCL, is present for the state respondents. In view of the above submission made by Ms. So-and-so, the petition being infructuous, stands closed.
May I please your lordship? My lordship, I beg to mention item number 32 for adjournment as the conducting counsel, Mr. N. Barwa, is suffering from an eye infection due to which he is unable to appear today.
Adjourned for how much time?
Your lordship, there is an interim order and the interim order may be.
How much? 2 weeks or what?
Yes, yes, your lordship.
Okay, on the prayer, Miss
Miss M. Lalsim.
M.
Lalsim.
Learned counsel for the petitioner. The list, the case on so a mention memo to the effect has also been circulated yesterday. The interim order passed again shall continue till next date of this thing.
May I please, your lordship? Well, I'm a owner of a tea garden, my lord. I have filed a writ petition today. There is some urgency. The expression of interest has been floated on 7th and the date is fixed for 12th for submission
7th?
and opening. Yes,
7th of February.
March, my lord.
March.
And the date is fixed tomorrow, my lord. And my registered office is in Calcutta. I was aware of this order without serving, my lord. I came to know from
No,
newspaper.
but
on
what tender notice?
My
Expression
lord, may be taken up today or
What
tomorrow.
expression of interest?
My lord, for attachment of the tea garden, my lord. They're appointing the receiver for 12 years, my lord. Instead of
By
saying tea
whom?
garden. By the PF department, my lord.
By PF
Provident Fund
department?
department, my lord. Tea estate, there was a due of Provident Fund.
Tomorrow.
May I please your lordship? I beg to mention for listing.
Motion,
No, lordship. Old matter.
give it to the court master.
My lord, I beg to mention item number 21, my lord.
Item number
21, my lord.
21, yes.
3 weeks time may be granted to file our affidavit in reply, my lord.
Mr. H.K. Sharma, learned counsel for the petition has paid for and is granted. He is trying to file counter reply affidavit. Post up. A mention memo to that effect has also been circulated yesterday. List the case on sales.
6-4. My lord, there is an interim, my lord.
The interim order past idea shall continue.
Much.
Daily list promotion, item 1.
Yes,
My lord, instruction was.
buying short
Yes.
time. Yes. Buying
Well, as on my instruction, my lord, they have not found any reference as on today. So it may be disposed of as there is covering this one.
Yes, Mr. Chaudhary.
Yes, my lord, my petitioner
B has been tagged, my lord, in the
Ah.
Bhutan list, my lord. So, my lord, he's
And Mr. A.H.M.R. Chaudhary, learned counsel for the petitioner. Any CGC? Where is Mr. Roy? A. Gayon, Mr. A. Gayon, learned central government counsel for the respondent number 1. Mr. J. Pai, learned standing counsel. Home and empty matters.
Yes, ma'am. Respondent number 3,
2.
3,
2.
2 is my lord.
Home Department.
Yes, yes. Sorry, but 2, yes, ma'am. I'm looking another
Ah,
petition.
2.
Yes, I'm appearing for 2, my lord. 2, then 5, my. Oh no, 2 only, ma'am.
2. Ms. Udas, learned additional senior government book expert, respondent number 3. Ms. S. Kotoki,
Lordship.
learned standing counsel.
My
elected
lord,
counsel, yeah. SP is
my
not
lord,
there.
SP is not a party, so SP should be met party. Then only SP can reply. Otherwise, it will not be.
Okay. Which district?
District Nagaon.
Respondent number 4 and 5. Victor. On the oral prayer of Mr. Chaudhary, learned counsel for the petitioner, comma, which is consented to by the learned counsel for the respondents, comma, the superintendent of this border, which district?
Nagaon.
Nagaon, is impleaded as party respondent number 6 in the instant petition. Full stop. Mr. Chaudhary, learned counsel for the petition, shall file an amended cross title before the registry during the course of the day, so as to enable the registry to make the necessary correction in the cross title as well as in the CIS post of para. The petitioner has opposed this court by the instant writ petition, stating in the relia that he is a permanent resident of village number 1, Borali Mari, police station, Juria, district Nagaon, Assam, post of. The petitioner has claimed that the name of his grandfather appeared in the voters list of 1965. So thereafter, comma, the name of the petitioner's father also appeared in the voter list from 1977 onwards. The name of the petitioner also appeared in the voter list from 2005 onwards, along with his family members. However, since 2011, comma, the petitioner's name was marked with D, was marked as the voter in the voter list. Agreed thereby, the petitioner filed representations before the respondent number 4 for removal of the D voter tag, as no action seems to have been taken on such representation. The petitioner is before this court by the instant writ petition. The petitioner has stated that his name should the voter take from in the voters list. From which constituency? Constituency?
my lord,
Hmm? Number 83, Dhing.
Thing, my lord.
Huh?
Thing.
Legislative Assembly constituency. Fair enough. Constituency change করে দিব সুপারিনটেন্ডেন্ট অফ পুলিশ বর্ডার নগাঁও করে দিব
All right.
7 over প্যারা 7 over.
Item 2,
My lord, I have inquired to the petitioner, my lord. He do not have any other document left, my lord.
Okay, well, you should notice, heard
Mal.
Mr. A.R. Bhuiya, learning
Mal.
counsel for the petition and Ms. Udas, learned additional seniors, government advocate for all the responses. Most of.
My lord, for finance, oh, sorry, no,
Huh?
I'm a finance.
Or let notice be issued. The notice.
Commissioner.
No, take it.
On so and so. For the police,
Mal.
as Ms. Das appeared accepted. No formalities, extra space. Two working days. The respondents shall ensure that the accountability is right on or before the return.
Oblige.
Item number 3. For the end of the last order, I am submitting the dates, my lord. My lord,
Tell me your statement. When you become the registered owner.
para 5 minutes.
Tell me date.
Date I have not given, my lord. Date I have not given in a pleadings, my lord.
You said,
Yes, my lord, I have
tell
submitted.
me,
On 5519, it was registered on 11/3/2025, and 5518 was registered on 12 March.
11,
11/3/25, my lord.
11/3/25.
And other one is
What is the
12/3.
cutoff date?
Cutoff date is
12/5.
12/5.
12/5, my lord.
12/5.
25.
What is the clause?
Yes, ma'am. 203, ma'am.
203.
Yes, ma'am.
No, first in the main document,
My lord. Yes, ma'am.
eligibility criteria.
Yes, ma'am.
In the main one,
Page 38, ma'am.
is
38.
38.
The pre-qualification criteria.
As on the closing date of tender. What was the last date then, at that point of time?
34 to 2025, that is final, ma'am.
34,
25, page 129.
129.
Yes.
It is fee submission.
Yes.
When it has been transferred.
It is transferred on 11/3/2025, my lord. The vehicles were, my lord, transferred on 11/8/25 and, my lord, 12/3/2025 respectively, my lord. Two track I have given, my lord.
It is a fee deposit. It is fee deposit.
Yes.
It is date of submission of application.
No, but next page, my lord. At bottom, my lord, transfer date 11/3/2025, my lord.
Hmm? Transfer date.
Yes, my lord.
Transferred at 11/3/2025.
Yes, my lord.
Hope Singh Bansal.
Tapa among the 11/3/2025.
The peso license to one.
Did you upload it?
Yes. Yes, my lord.
My lord, yes. My lord, pursuant to our last hearing, my lord, in the matter, since the lordship had raised the query, I had taken it up with the IOCL. The IOCL had also taken it up with PESO. The fact is, my lord, the corrigendum which has been relied by my friend 6/4/2025, it pertains to vehicles from other states, like a lordship had said, for example, GJ. Now, for a vehicle from Assam, AS01 or whatever that might be, my lord, it is also a requirement under law that the PESO license also has to be linked to the current owner. That is the stand of the PESO. If your lordship now, since my lord, notices have not been issued, in the interest of time, my lord, if your lordship grants me 4 days time, I'll get a written documentation from the corporation to state whether that corrigendum was applicable and whether the PESO mandates that it has to be linked to the current owner. That I can assure your lordship that I'll assist this court, my lord.
Okay.
And also, my lord, from my friend for this honorable court, since substantial time has also lapsed, my lord, provided this matter is allowed, just in case, my lord, if it is allowed, my lord, the allotment has also been done. That is my duty to have pointed out, my lord,
Yes.
the allotment and work orders. But I'll assist this court, my lord, on the next day. I'll have a written documentation from PESO as to what is the requirement.
We are examining the case whether to proceed further.
True, my
If
lord.
allotment is made.
True, my lord.
We cannot disturb that allotment.
True, my
But
lord.
whether he has made out a case to proceed further from the
Yes.
motion stage or not.
Yes, my lord.
We are examining that on.
My lord, I'll have written instructions on the next day, my lord.
Okay.
If a week's time may be
Okay,
granted,
then.
my lord.
Because otherwise you.
Yes, I know.
You come with a delay.
Yes, sir. Admittedly, there is substance.
So whether to waste our time in future or not
Yes, sir.
with this bulky writ petition. If it is of no value, we will not proceed further.
Yes.
That's what.
My lord.
Okay. Heard Mr. S. Botagur, learned counsel for the petition, and Mr. M. Sharma, learned counsel for all the respondents. So Mr. Botagur has submitted direction. Insofar as the ownership of the two vehicles, ownerships of the two vehicles are concerned, the petitioner owned the two vehicles registered in Assam on and from 11/3/2025. And as such, one of the grounds of rejection for his technical waiting is not tendered post of Mr. Sharma, counsel appearing for the respondents.
IOCL, my lord.
IOCL authorities have sought use time to obtain written instructions in a matter and also as regards the two grounds of rejection of the bid of the petition.
My lord.
Please the case on so next witness.
20.
Please the case.
1803. My lord. I'm grateful, my lord. If I may pray, my lord. The matter can be fixed kindly on 20th, subject to your lordship's convenience, my lord. On Friday, my lord, if it is convenient to this phone.
Okay.
2003. I'm grateful, my lord. Item 4.
Here we have silenced the order of the local understanding. That is in case number 55. Case number 55, order dated 8/3/2025. Case of parties are represented since petition number 1212/2005 jointly by the plaintiff and the decree number dependent number 124 praying to pass a compromise decree showing the ground that they have settled the dispute as per terms and condition of the petition number so and so. Pardon, it is seen the dispute between the parties settled amicably, hence the prayer filed for the passing the compromise decree is allowed, and in this regard, parties have put their signature on the local settlement from the same is kept on with the case.
Where is the plaint?
My lord, yes, my lord.
Plaint.
Plaint, my lord. Here, my lord, plaint, I think the plaint, my lord, here what happened?
It is there,
But yes, plaint.
page 16.
Plaint-
Page 16.
Oh, sorry, my lord, this is the compromise.
Plaint.
Yes,
Plaint of the commercial suit.
plaint.
Page 16.
My lord, kindly see on page number 60, my lord.
Page
This is
16.
The joint petition.
Who is the petitioner?
Here, my lord, petitioner is.
Director General Sports Authority of India.
Yes. Here we are.
Defendant number 2.
Yes, defendant number 2.
Okay, what happened?
What happened, my lord? In this case, first, we have signed in the compromise, joint petition signed by all the parties except Union of India. That is also one of the parties. Kindly see, my lord,
Union of India. Union of India is
is a performer defendant in kindly. See.
principal defendant.
Yes.
Okay, defendant number 5.
Yes, defendant number 5 and defendant number 2 before the lower court, my lord. So what happened, my lord? Kindly come to page number 60. This is the type copy. And kindly, original copy is in page number 63, my lord. Page number 63. And detailed copy, my lord. And kindly come to paragraph number 5 of page number 64, my lord. Paragraph number 5, my lord. Here,
Please read.
paragraph number 5, my lord, this is
In
that in
compliance
compliance with
with
the aforesaid, all the parties above agreed to exist the compromise degree and when so required and shall be submitted sent before the honorable court. That is in
no, come to paragraph 4.
paragraph 4. Yes, my lord. That it is also adduced by defendant number 1.
Accrued or what?
That is, my lord. Accrued as per their that is written by them.
By
my
the
lord. Is
1,
accrued
3, and 4 upon receipt of fund from reference number 2, same shall be released with the plaintiff.
Plaintiff forthwith, my lord.
Forthwith.
Then what happened, my lord? This is the petition filed before the local and put their
Madam,
signature.
you yourself have signed.
No, then kindly see, my lord, come to next page number 66, my lord. Here we have signed, that is fact, my lord. Kindly come to page number 66, my lord. This is the type copy and come to page number 69, my lord. Is the
Defendant number 2 has signed.
yes, my lord. And kindly
And
come
you yourself have signed the petition.
yes, my lord. What happened, my lord? Kindly come to page number 69, my lord. 69 and 70, my lord. Paragraph number 5. That is compliance with the aforesaid facts of all the parties herein above agreed to execute the compromise and when so required and that submit the same before the honorable court. On failure to, there are some lines were added, my lord. Kindly see the next line. 1, on failure to pay the amount by the defendant number 2 will lead to execute the proceeding against him. So, my lord, kindly see page number.
They are in the compromise petition.
Yes, my lord.
It is the defendant number 2
Yes, my lord.
who had owned the responsibility,
Yes, my lord.
right?
Yes, my lord. My lord, kindly see. my
Just a
lord.
minute.
Yes.
This page 60.
60.
60, before the local law.
Yes, my lord.
This petition was filed,
Yes,
right?
yes, my lord.
By 1, 2, 3, and 4
Yes, my lord.
jointly
Jointly.
with the signature of the council,
Yes, my lord.
right?
Right.
There you as a defendant signed.
Yes, my lord.
And what is this petition? It is also a same,
Same
page
petition,
66.
63 say.
And there the text and tenor of paragraph 4 in
Yes.
page 61
Yes,
is same,
yes,
is same.
6.
And otherwise that part
Yes,
is the only consequence.
yes, my lord.
If not paid
Yes, my lord.
by defendant number 2,
Yes, my lord.
then automatically lead to execution. That is law.
That is law, but
That is law.
when we signed that if they compromise petition, that
Oh,
was
but
not there.
did you deny page 60,
Yes, my lord.
page 63? Did you deny?
Page 63, we are not denying.
Then,
Kindly come.
and how after signing this page 63
My lord.
and thereafter this award, page 59A,
Yes.
where your sign also appeared,
Yes, my lord.
right?
Yes, my lord.
Then how can this defendant number 2
Yes, my lord.
can prefer this writ petition?
My lord, what happened, my lord? That is,
This cannot, they cannot.
no, my lord, kindly see, my lord, that defendant number 2, kindly see, paragraph number 3, page number 60, my lord. This is settled amicably upon the release to claim amount by the Union of India, Department of Sports to the defendant number 2. Same shall be released to the defendant number 1, 3, 4 along with the interest, my lord. When Union of India, Sports Authority of India will release the amount, then only we can disperse the
It
amount.
would
my
be
lord.
open for Union of India to say
Yes, my lord.
that this paragraph
Yes,
has been added
yes.
without our
Consent.
presence.
Yes.
But here the petition is filed by Director General,
Director-
who was defendant number 2.
Yes, my lord. Why you have filed, my lord? Kindly see, they have added some line in that.
That is not acceptable because that is normal course is execution.
Execution, my lord, but they
But
have.
paragraph 4 you have undertaken, paragraph 4 page.
Paragraph 4 undertaking.
Miss
paragraph
Gayan, I
five.
am not satisfied.
My lord, in similar case.
I am not satisfied.
Please, my lord, I'll bring before that, my lord. They kindly take another date, my lord. Notice has already been issued in the same case, my lord.
Maybe. But how can this be?
My lord, kindly see, my lord, one thing, my lord, paragraph number 5, my lord. Paragraph number 5, they have, and also in the prayer portion, my
Madam,
lord.
if you want if you want to allege that fraud has been committed in the court record,
Yes, my lord.
then go for 340 CRPC, file a complaint.
But my lord,
Miss Gayan, this statement, after this petition,
Yes,
an award has been passed,
yes, my lord.
right?
Yes, my lord.
You want to say that this line has been added
Yes, ma'am.
subsequently after filing of the petition before the court,
Yes, my lord.
then it is a fraud.
Yes, my lord.
Fraud
Yes.
committed in the court record,
Yes, my lord.
right?
Yes, my lord.
Have you seen section 195 IPC and section 340 CRPC? Without resorting to that,
Yes, my lord.
don't make such an allegation before the writ court. Have you understood?
Yes, my lord.
What is 195 IPC? Without following the steps, you are alleging that fraud has been committed in the court.
Also, evidence we can put is the conveyance of offense.
Fabricating false evidence with intent to procure conviction so and so or so and so. Then next 340 CRPC.
For to initiate the inquiry into the offense affecting the administration justice such as forgery and fabrication.
So you are saying fabrication of the document,
Yes, my lord.
right?
Yes, my lord.
Adding one more line in paragraph 5 after filing of the petition, because your signatures appear there.
Yes, our signature is there, my lord. That is true, my lord. Our signature is there.
You yourself signed it.
Yes, my lord. But when I took that, when I got that certified copy, then only we can see that line. We could see that line, my lord. But my lord, 226 have the power, my lord, to.
226, I know the limitation of power in respect of a low Adalat award.
Yes,
There is no other provision except 226, but that too in certain cases. But here, from the record does not emerge prima facie that, because you have to create a ground. And you sign it yourself,
Yes, madam.
Director,
Yes, madam.
Sports Authority of India.
Yes.
Now you are turning back.
No,
Look.
I'm not turning back, my
No,
lord.
it seems to be.
No, I'm not turning back.
And it
This
is not the case that
verification.
paragraph 3, Union of India, if Union of India is aggrieved, they should prefer a leave petition,
Yes, madam.
not director. And for that director to approach, he has to say that after filing of the petition,
Yes, ma'am.
joint petition, fraudulently some more sentence was added.
Yes, ma'am.
Where is that? And you have to make complaint to that court.
Yes, ma'am.
Sitting in writ court, how can we assume and presume all these things?
Madam, kindly fix the matter Friday. I'll withdraw the matter with the I'll take instruction from them. Madam. Fix on Friday, my lord.
Because otherwise, how can we proceed? The defendant, this defendant,
Yes, my lord.
himself, so far as say for at least page, come to page 61.
Yes, my lord. Yes, my lord.
Paragraph 4,
It is also acquired by the defendant.
1, 3, and 4. Upon receipt of fund from the defendant number 2,
Yes, my lord.
you are defendant number 2.
I'm defendant number 2.
The same shall be released to the plaintiff forthwith.
Yes, my lord.
You sign it.
Yes, my lord. Well, then come to paragraph number 3, my lord. Once the Union of India release the amount, then we will release that amount.
Ah.
Yes, my lord.
You have said.
Yes, my lord.
You have said. If
Yes,
execution
But
is execution petition is filed,
Yes, my
you
lord.
take the plea.
Yes, my lord.
You take the plea. My acceptance was
Yes.
subject to the condition
On paragraph
Union of
number
India
3.
would pay.
Yes.
Only then I'll release.
That's why specifically they have put the line. That's why we are on.
That I don't know. This is
Yes, ma'am.
by making mere allegation, you cannot delay the matter. This is, I don't know, because after that, all the signatures are appearing on the right side. Next, in the prayer portion also,
Yes, ma'am.
it is there.
That is fact, my lord. Signatures are there, my lord.
That court is capable of examining that. How can we examine all this?
So, but kindly fix on Friday, my lord. I'll take the step.
This is otherwise unnecessary wastage of time.
Friday, my lord. I'll
On a
take
request
later
of this.
withdraw, my lord.
A guy on Learned Counsel for application raised the case on Monday. Learned Standing Government Counsel for the petition raised the case on Monday.
16-3.
Item number 5.
Yes, Mr. Pathak, take instruction. Why?
My lord, I have already received my instructions. It appears that the land on which the petitioner applied, he projected the land to be Dag number 690. Upon a physical examination of the land through the circle office, it appears that it is 698, on which another person has also applied for electricity connection. And in the Dag number 690, it appears that there is already an existing electricity connection by somebody.
You claim in respect of which Dag number?
That is very clear, my lord, in the decree.
Clear, please tell me.
Yes, yes. Six 90, my lord.
Page.
650 old
Page.
page of also will see. taking. Yes, just a second. There is already a decree in my favor, in respect of the land.
Right,
That your
right.
lordship is
I'm
taking.
not saying that.
But my lord,
Now, what is the dark number?
the application, that is not there, but in fact, if your lordship, let's take it to page 56.
We come to the decree,
The decree, yes,
judgment.
yes, my lord. If your lordship see.
Let us see your prayer. Sorry, claim in the judgment.
I'll just take it before.
The
Page
plaintiff
55.
is in view is a absolute honor so and so, one kind of violation, dark number so and so. Converted. Come to page 27. You are the plaintiff?
Yes, sir. I'm the, my father, in fact, my father was initially.
Right,
plaintiff,
you
but
are the
then
plaintiff.
Substitute, yes.
You are the plaintiff.
Yes, sir.
Read page 27, first paragraph.
Is after the. This is the absolute owner position of a land measuring 1/4 so and so covered by dark number 650 old. After the settlement operation, old number so and so, converted 690. Has been converted to new dark number 690 by creating a new patta number 1.
And who is defendant?
The defendant will not,
What is his name?
He was Vishnu Pado Milot Saha, but he was being, he expired and the cases was being contested by the power of attorney holder. That is Potluddin.
Produde.
He claimed to be.
Let us see his case. B.
In fact, there was a counter.
Let us see his case. B. Page 27.
The defendant has his land measuring 1/4 14 lashes of covered by the old dark number so and so of NKF so and so, which is on the eastern side. Just behind this suit land on the other western side of the suit land, there is a byline named byline 1, which is connected from one side of the main.
So your suit land is dark number 63, which has been converted to 690.
Lordship.
Right?
If your lordship kindly comes to page 35.
I'm going to page 35.
Page
Yes.
35, my lord. Cross 9, my lord. Accordingly, in view of the above discussion, I find that the plaintiff has right, title, and interest and position over the suit land mentioned in the schedule of the pay. Now, in fact, there was a counterclaim. If your lordship kindly comes to page 37.
1 minute. 1 minute.
There, he had with both of them.
Just a minute. Just a minute. Both of you, page 34, paragraph 7. Dark number 63 old, 690 new, and NK patta number 15 old, KP patta number 116 new. That is petitioner. Right? Now come to page 35. Discussion and decision on the issue. You read forward from 1 to 3 up to 4.
From the perusal of the matters on record, it appears that the defendant has claimed that yes, his total blame measuring on so and so, that number 64,690 in the so and so. However, as per the report of the Army Commission, it appears that the that number has turned into that number 690 new, not that number 64 as claimed by the defendant. Thus, that number 64 old and that number 64 are two defendants. Thus, the report of the Army Commission shows that the defendant has his land in that number 661 and not in that number 64 old. So it is there is a defendant. And the defendant does not have his plot. There was a counter claim. Does not have his plot of land on in that number 64 old. He has his own land in 661 old, which is later on turned to be 698 new. According to the point of determination is decided in negative and against the defendant. So this has again gone in my favor. A discussion in respect of issue number 5, page 36.
Now your instruction,
Before that, my lord, your lordship.
no, Mr. Pathak, your
My lord.
instruction was actually 698.
Yes, that is what they have told me.
Lordship, there is a report of the AGM law at page 56. This is he is a subordinate officer, the person who has rejected my application. And this is the report of a AGM law narrating the entire facts. The Podu, they had a temporary connection initially that was disconnected pursuant to the order of the civil court.
Page 60, just because his name is not recorded in the land records, at least he has a decree,
He has a decree.
judgment and decree in his paper. Unless it is upturned, he is the owner,
He is the owner of dock number 690.
690. Now, what is the, because DGM law says his application deserves consideration,
Consideration.
right?
Yes.
And page 57,
Yes.
Projut Kumar Day, second line.
My lord.
It is opined that the request of Sri Projut Kumar Day for reconnection of electricity supply cannot be entertained at this stage. This is DGM law saying,
Yes, your lordship.
right?
Yes, your lordship.
And this is written to SD Jalukbari ESD. Now, Jalukbari ESD, as subdivision engineer, he says, page 60.
60.
Your name is not recorded in the land records.
That is why he has rejected.
But DGM law says,
DGM law has, it is there, your lordship. So that is why I placed this. Otherwise, your lordship, there is a Supreme Court judgment which says that since it's an essential
Right.
utility, we should not go into these factors, your lordship.
no, you have created some mess due to dispute of two applicants. Now,
sir.
where is the circle officer report? That as if circle officer is saying that petitioner is occupying dock number 698.
The report appears to be at page number 59. I believe this is the report. Yes. I could not find any other communication from this.
Yes, this is the report,
This is the report.
This is the report.
page 50.
Of the dock number 698 is vacant.
Vacant. And this is,
Lordship, there is another interesting factor. Here, he is calling for a report from the circle
And
officer.
it was not possible to submit a different report earlier, position than late. Nameplate varying the name of transit and the office. He did not visit dock number 690.
he did not visit dock number 690.
Huh.
From this report, it appears that he has not
He
visited.
did not visit.
He has not.
So,
In fact,
DGM law says
But-
after due consideration.
Because otherwise,
if both the persons are occupying,
Yes, your lordship.
or what is the reason for disconnection of that Pradyut day?
That
It was on the basis of my complaint. And in fact, if your lordship says in the suit, page 62 will. The report from the Amin Commission or the Director of Land Report was, there was an inquiry was held, page 62, 63 is the schedule. And if your lordship sees the report at page 64. So, the circle officer cannot be higher than that of the DLR. It is a report of the DLR on verification of report verification. And this was relied in the suit on the basis of the court's order.
আবেদনকারী দখলত আছে।
On the, this was, my lord, during the trial of the suit.
Sound electricity. So 690 is in his position.
690 is in his position. What he has told, that's why I asked him to give it to me in writing. What he has told me, the officer concerned, who has passed the impugn order, that the land, when they visited the site, it appears that is a different plot of land. And in 690, there is already an existing electricity connection. The last line of this instruction,
Yes. Do you have electricity connection or not?
No, my lord. That was there in the name of Padut Kumar Dev, my lord.
No.
Yes.
Trying to prohibit you.
That I am thinking so, my lord. To my instructions, no. There is no connection. It's a vacant plot of land, my lord, where I have, it is, my lord, in the, it was a vacant plot of land, my lord, there is a shade. This was a subject matter of litigation, my lord, there was no, otherwise, my lord, no.
Cannot be an existing connection in your name.
Exactly, my lord, that cannot be.
What is the detail? You find out the details of this connection.
existing connection.
Let a copy of this may be handed over to me, lord. I'll take instructions as well.
This consumer number, meter number, connected load 12 kilowatt,
Very
12
well.
kilowatt, not small
Yes, your lord. It's a
load.
Yes.
Category domestic B in DAG number 690.
There appears to be an
Maybe
existing.
something is wrong somewhere.
Yes, your lord.
So exactly, my lord. See, if there is so, my lord, that could, it could have been, my lord, informed earlier, my lord. The ground of rejection is that my name is not tweeted in the record.
Everybody first rejects it. Right. Thereafter, if some complaint comes, then only inquiry. Right. Everybody put the cart before the horse. First reject.
Yes, sir.
If he comes back again, we'll see. That is the way of doing things.
Whatever instruction, my lord, let it be.
I'll give my
Mr.
learned friend a copy.
R.A. Learned Counsel for the petition. Since it is a vacant plot, you have no urgency. As you said,
Yes, but in fact, we are trying to develop it, that is what.
and Mr. K.P. Pathak, Learned Standing Counsel, APDCL. Post of. For
Respond numbers 1, 3, 4, and 5.
1, 3, 4, and 5.
But this person should also be made a party, your lordship. This other person should also be made a party, your lordship.
Let us see. And we have revenue. Pierre Monto. Revenue 2 and 6. Udas. You created the mess. Traditional senior government bullet for the respond number 7. Post of by virtue of a judgment and decree. Or it is selling somewhere?
No, my lord. In fact, recently appeal has been filed, my lord. In
Appeal.
fact, yes, appeal is pending.
Any stay?
No,
By virtue of its judgment and decree. Past. Dated 30 6/2025. Passed by the Court of Civil Judges, Junior Division, number 2, Kamrup Metro, in title suit number 369 of 2010, wherein the petitioner was plaintiff number 2, which the petitioner's mother as the plaintiff number 1, after death of the original plaintiff, who was the petitioner's father. The petitioner, petitioner, that's plaintiff number 2, along with the plaintiff number 1, have been declared as the owner of a plot of land. Owner and possessor of a plot of the street land. That is a plot of land measuring 1 kata 5 lesa, covered by tag number 633 within bracket old stroke 690 within bracket new of an NK Patna number 15 old is 34 stroke KP Patna number 116 within bracket new at located, situated. No whisper about the area, a village.
Village Maligaon.
Village Maligaon, Moja, Jalupari.
That is the schedule.
Gauhati Revenue Circle, subject clause. Post. After the judgment and decree, the petitioner applied for an electricity connection in connection with the subject plot. However, the response number five rejected the application for electricity connection, submitted on 5/7/2025, on 6/1/2026, on the ground that the petitioner's name is not recorded in the land records against the subject plot. First of rejected question. Para Mr. Day, learned counsel for the petition, has submitted that in the title suit, one product day was the
Attorney order.
defendant.
Who was the attorney holder of the
So that's attorney holder of the original defendant and substituted and a legal representatives of the original defendant. Close talk. It transpires that Procedural had also applied for reconnection of one electricity connection for in a plot of land covered by diagram number 698. Full stop. Mr. Day has also drawn attention to a report submitted by the respondent number 4. Office letter dated 23/12/2025 of the respondent number 4 addressed to the respondent number 5, wherein it was opined that Pradut Kumar Day would not be entitled for Pradut Kumar Day's application for connection of electricity connection could not be entertained at this stage, and the application of the petitioner for electricity connection would deserve consideration, and the same should be processed in accordance with law and the applicable supply code, purely on the basis of position and identification of the premises, and subject to confirmation that no appeal or stay is in force against the judgment and decree dated 36/2025. Mr. Day has also drawn attention that during the course of the proceedings of title suit number so and so, a field inspection was carried out as regards the subject plot, and as part of field verification report, the petitioner was in possession of the subject plot. Full stop. Where? It transpires that the respondent number 5 rejected the application of the petitioner for electricity connection pursuant to a report submitted by the respondent number 7 on 5/1/2026. Who is the report?
Page number 59, Your Lordship.
The report, the copy of the copy of the report of the respondent number 7 is annexed to the petition as annexer Roman 10 to someone perusal of the report, it is noticed that the respondent number 7 had only visited the plot of land covered by diagram number 698 and not diagram number 690. Full stop. Where Mr. Pathaklan, Standing Counsel, APDCL, has submitted on instruction that there is already an existing electrical connection in the name of Tanjit Devnath, bearing consumer number so and so, meter number so and so, and meter number so and so with load, connected load 12 kilowatt and category domestic B in dark number 690. That is the subject plot. So both will take instruction.
Very
This has to be resolved
Yes.
without going into notice days.
Very well.
Both Mr. D shall obtain instruction as regards the purported existing the existing the aforesaid electrical connection purportedly existing in his name. Mr. Pathak shall also obtain instruction whether the decision of the respondent number 5 was taken on the basis of ownership and possession of the subject law. That is, which is covered by diagram number 6.
Interestingly, because this was a temporary connection, it's not a permanent connection. There is otherwise no bar as such.
No, 12 kilo load is not an easy joke, Mr.
That is
That is true, Milord. That is why Milord, sometimes Milord say, Milord,
Sometimes clients become small also. Let us see
yes.
who is correct. Release the case on.
Lordship may perhaps like to keep this instruction on record.
It is there.
Very, very well. Lordship.
But this is erroneous report.
Yes, that is why
That is why I am not taking cognizance of it.
because after hearing what he had to say, I specifically said that you have to give this to me in writing because I mean the facts are so convoluted that otherwise
Now
it
you
becomes
realize, so release the case on so and so.
very well.
23rd March, 23
Consumer number, you will clear.
Very well. Deeply obliged.
Item number 6.
May I please your lordship? Lordship, today only I have received the extra copies from them for instruction.
no order for extra
But-
copy, Lordship.
But lordship, I have already asked for instruction over phone to them for the from the
Yeah.
department. Lordship,
What is your
kindly.
instruction?
But lordship, till now they have not given because they require extra copy. They ask for the extra
They
copies.
require extra copy.
Kindly at least
this is
1
the
week.
Fault of the court,
No,
right?
No.
You should have reminded the court.
Huh.
If they
Yes,
really
yes,
require
sorry.
extra copies,
Yes, lordship, that's
Court-
my fault.
court don't remember
Yes, lordship.
always that you need extra copies.
Yeah, yes, lordship.
Okay, D Deca petitioner. A Soikia standing out of exercise 1, 2, and 3. UDAS 4 and 5. Miss Soikia has sought for a further sought for 1 week's time to obtain instruction. What is the direction of the court?
Lordship.
To obtain instruction?
Last order, Lordship, on 6.
No. That breakup. Breakup 1. There was breakup, right? Direction to something was there.
Lordship, with regard to the earlier order, Lordship. Lordship. 37, page number, NX of 5.
Yes, number 37. Which part?
Lordship, we kindly go to the page 41. Roman 2 is the number. Second, Roman 1 and 2.
No, that paragraph 10. Paragraph 10. The competition, the basis of which the impugned demand notice was issued. That is the line. That is your case only.
Also, the license that we have applied for cancel, surrender of license, which has not been accepted, subject to the payment lordship. So that will come only after the payment part is possible.
On a time, raise the case on so and so, the earlier interim order shall continue till the next to the list.
2003.
Now you are with extra copy?
Yes, Lord. Just now, a few minutes before they have given. Obliged lordship.
Item number 7.
Yes.
In this case, my lord, the petitioner's younger brother with license, IMFL, my lord, and he expired on.
That experiment had some issues, right? Earlier?
Earlier, yes.
Uh,
And.
That was withdrawn.
Yes, that was withdrawn after his death.
Yes, is there any provision?
Yes, Lordship, 301 says that transfer is applicable on death of a licensee. Now, here the issue is that this Dilip Kumar Bhumik, though he's a brother of the licensee holder, the license holder has two wives, Your Lordship, not one. So NOC has to be obtained from both the wives. One has given, one has not given the NOC, Your Lordship. In fact, I have the instruction for that, Your Lordship.
But first one is the legal one.
First one is a legal one. And the issue is that the first one,
Illegitimate wife.
second one,
How, if she is not recognized in law, how can excise authorities can take NOC from her?
but this first wife has,
Which one is it?
first one.
Heard Mr. B. Prakash, submit your affidavit,
Very well, Lordship.
and Mr. R. Gogoi, Land Standing Council Excise Department for the response number 1, 2, and 4.
1, 2, and 4, Your Lordship.
Mr. S.R. Borua, Land Junior Government Advocate Assam for the response number 3. Post of the petition has stated that he is the brother of one late who was granted an IMFL on license by the respondent authority, by the excise department, respondent excise department, post of after the date of Porimal Kumar Bhumik, on 15/10/2025, the petitioner petitioner has applied for transfer of the license, IMFL on license in his name. Post of the petitioner has stated that a death certificate and a no objection certificate from the wife of Porimal Kumar Bhumik have also been submitted. Yet the application for transfer of the IMFL on license has not been effected till date. Post of Mr. Gogoi, Land Standing Council Excise Department has submitted that the transfer, any transfer is to be made as per the provisions of section
301. Assam Excise Rule
301
301.
of the Assam Excise Act 2000,
Assam Excise Rule 2016.
Assam Excise Rule 2016. 16. Full stop.
The instruction which I submitted, it says that she is the first wife, Your Lordship. That reflects in the third paragraph, Your Lordship, of the letter. Objection.
Third paragraph.
Third paragraph, that I am the legally married first wife of late Porimal.
She made the application.
Yes, she made the objection.
Okay.
And further, another instruction I have, the Superintendent of Excise, Highlighted, has already written to the second wife to submit documents which she has not submitted till yet, the marriage certificate, anything.
Okay. The another application from one Sheila Day, within bracket, Homik, has been received another application for transfer of the IMFL on license of Porimal Kumar Homik has been received from one Srimati Sheila Day, within bracket, Homik. Full stop. Upon receipt of the said application, comma, the respondent number 4
Respondent number 4.
has written to one Srimati Priya Bhumik, who also claims to be the wife of late Porimal Kumar Bhumik, regarding the application, inviting comments, stroke objection, and objection with regard to the application submitted by Srimati Sheila Day, within bracket, Bhumik, and has also requested Srimati Priya Bhumik to submit documents in support of her clean marriage with late Porimal Kumar Bhumik. Matter would require consideration. Issue notice, returnable answers. So you have two more opponents. This is not now going to be tenable without including the parties.
Exactly.
As so and so here, formal notice, no formal, the extra copies two also. So two more opponents.
So you have to implead them, Your Lordship.
And they are better by virtue of law, they would be in a better position, class 1. Then among them, between them, who would be the best one? Better one. So first wife or second wife. So you are out already. You are out already. 5 is between first wife and second wife.
Obliged, Lordship.
24th April. 2404.
Item number 8.
Yeah, Lord, the method related to non-payment of contextual bail.
Heard Mr. R. Burwal and counsel for the petitioner. As Dr. Revenue Disaster 1. Water Resource, Miss Tai. Is here, you are. On behalf of R.M. Das. 2, 3, 4. S.R. Borua.
5 and 6.
5 and 6. The petitioner has stated that he completed on the basis of an work order. He completed a contract work and he executed a contract work under the scheme. Synopsis high level. Where is the contract work? Work order?
Work order, Lordship, page number 14.
Page number 14. Immediate measure of so and so. 24/9/2019. Huh? On issuance of the work order, comma, the petition stated that on issuance of the work order, he executed the contract work, and a completion report was also submitted to the effect that the contract work was executed and an amount of a bill amount, so the petitioner approached this court seeking in the direction to the respondent authorities to disburse an amount of rupees 9,51,687. That is the total bill amount the petitioner had submitted against execution of the contract work. Issue notice returnable also and so. extra copies or no formal.
Item number 9.
May I please, Your Lordship? My lord, the petitioner before my lord is a law college, my lord.
Affiliation, whether bench for,
That's I'm
Huh?
thinking, my lord, it should go to bench two, my lord, perhaps.
bench, bench two.
Because, my lord,
Affiliation, bench two, something. By no way, this
appears to be bench four. my lord.
bench four method.
My lord.
Who has put the code? You put the code.
No, my lord, code is being put by the,
That is not the work, that is also the work of the advocate.
my lord.
You put it to the clerk. Sound E10-184, code to sound. Could be same. Code, on a bench for code to sound. Bench for code. Licenses and permissions.
Commercial establishment license is different thing.
Affiliation is different from license. This is academic matters.
My lord.
Mr. Air, learned counsel for the petitioner. Affiliation give a code so that's anything. Definitely try go affiliation code. Bench to code as Come back with code. Come back with code. That much exercise you have to do,
My lord.
not to leave it to the code.
My lord.
Item 10.
Maybe the lordship is matter may be taken across some level, lordship. Yes, sir.
What is this matter?
Lordship, my name is not there, my I alone will appear. He is on port number 14.
He has come, which
How you are agreed?
apprehension on apprehension he has come.
How you are agreed?
Lordship, I have no idea. Even brief is not with me. He has just.
Come back. Tell him. I'll dismiss it. I'll dismiss it. Tell him.
Item number 11.
Yes, what is this?
Regarding payment of bill for hire of vehicle.
Alright, Mr. S.K. Singh, learned counsel for the petitioner. Mr. S.R. Burua. 1, 3, 4, 5,
6, 7.
6, 7. Any finance? No. The petition, Mr. M. Via, learned counsel on behalf of Mr. B. Govil, learned standing counsel finance department for the respondent number 2. The petition stated that he is the registered owner of a vehicle bearing registration number so and so. Synopsis of the subject vehicle person. During the period from 19/7/2018 to 1/5/2020, the subject vehicle was taken on hire by the district administration West Karbi Anglong from time to time, and during the said periods, the vehicle was used by the respondent number 7 for law and order duty, etc. The petitioners had submitted his bills for different periods for a total amount of rupees 8,09,400. As despite repeated approaches and representations, the said amount bill amount has not been released to the petition till date. The petition is before this court by the extended petition. Issue notice returnable so and so, as so and so, so and so, extra copies.
2704.
Iman?
2704.
Item number 12.
বইছে আছে দাদা
The voter.
My lord, actually what happened, my lord, in this case, a case was registered at Hateko police station. Then subsequently re-inquiry, lawsuit is filed with
Let me read the synopsis.
Case 30.
itu sekarang din tu dia internship region of Oslo.
Where is that letter? 2011-2021.
Case 32.
Page?
32.
Mr. Sharma?
Lordship, in this respect, Lordship, I have to take instruction because Lordship, once a person is marked as the Lordship, whether person concerned is the voter or not, it is a matter of factual determination. And appropriate forum for this is concerned foreigners tribunal, Lordship. Whether this case was forwarded or not to the concerned tribunal, Lordship, it has to be, and that instruction has to be taken, Lordship.
It is mentioned. He is
The
not
DP says
illegal migrant.
he is not an illegal migrant.
And
But Lordship, once he was marked as the Lordship, then opinion of the tribunal is required, Lordship. So, Lordship, I need to take instruction, Lordship, whether till that it was forwarded or not. A reference should be made, Lordship, and
No reference. I am involved in every tribunal in the district.
I have no reference, same order.
yes,
It
Lord.
has to be informed and we'll close this. Yes, anybody?
Mark D has been inserted in my original village.
It should be dropped then, if really nothing was there. Heard Mr. J. Ahmed. Learned counsel for the petitioner, Mr. Who is Central Government Council? Anybody there? Ms. S. Kotoki. Learned Standing Council, Election Commission of India. For the respondent number 2, Mr. G. Sharma.
3, 9, and 10, Lordship.
Standing Council, Home and FT Matters. For the respondent number 3,
9, and 10.
9, and 10. 4, anybody?
4.
Okay, you does additions in your government advocate for the respondent number 5, 6. 9 is 9.
9.
Huh?
9, I am appearing.
Okay.
I am
10.
9, 10, Polu.
Sharma, you're for 9 and 10.
3, 9 and 10.
The petition has projected that he is a permanent resident of village Torangapur, post office Tulsibari, police station Lakshmipur, district Gwalpara by birth. And the said area falls within the territorial limits of 39 number Joleshwar Legislative Assembly constituency, post of Para. The petitioner has found that his name was enrolled in the voter list of 2005 for the first time, along with his parents. Post of the petitioner continued to exercise his right to vote till 2010, post of. But in the year 2011, the voter mark has been made against the petitioner, and since then the mark continued till date, post of Para. On inquiry, the petitioner came to learn that a police case, what kind of police case? No, police station?
Police.
Huh? What kind of police case? No police station?
Deputy Commissioner Police.
Huh?
Order.
Cannot be.
It is
Case number 106 of 2010, who was registered against him on the allegation that the petitioner was an illegal migrant. Full stop. The response number 9. 9? DCB?
DCB Border Kamrup Metro.
Who wrote this letter?
Lordship.
That letter was written by whom? Response number 9. By an office letter dated 2011-2021. Memo number to the response number 7. Inform that the case, that is police case number 106 of 2020 against the petitioner was dropped on 17/11/2021.
Yes.
After re-inquiry. So it was opined therein that the petitioner was not an illegal migrant. Post of Para. Thereafter, the petitioner had approached the respondent authorities to remove the demark put against his name in the electoral roll, post of, by the respondent authorities. Post of, with the projection that the respondent authorities had failed to do the needful. The petitioner is before this court, and the article by receipt petition preferred under Article 226 of the Constitution of India for an appropriate direction that the devoter tagged with the name of the petitioner in the voters list be removed by legal 8, 9. Superintendent Police. Border.
Yeah. In Kamrup district.
So it will be 10.
Lordship
Oh.
9.
9.
9.
Okay, 9 on up to Superintendent Police or 9 to Litigation. Number. Which constituency? You are saying some other constituency.
Yes, I originally Joleswar constituency.
Joleswar falls under what?
Goalpara.
Goalpara district.
Then 9 and 10 both.
Yes, yes.
9 and 10 both.
Both. And my lord, election officer is letter issued to response number 8, not 7, my lord.
However, 9 and 10, you would inquire 9 and 10 both. Otherwise, your
Yes.
constituency is somewhere else. Gwalpara.
Yes, Goalpara.
9 and 10 both.
My lord, election officer is letter issued to response number 8, not 7, my lord.
Ultimately, it is FT.
Yes.
Dispose. Item
13, item 13.
May I please tell you, my summary is on leaves lordship and the password of the medical defense.
So you are not ready with the case? Huh? Not ready. What is the case about?
Non-payment of contractual.
Non-payment of.
No completion certificate, no seat. No nothing. And work orders of 2015, 20, 21.
You come up with that these are not maintainable. Due to laches, limitation. File your affidavit
Very
to
well,
that
Lordship.
effect, then we'll deal with it. But nobody comes up with that plea.
Will come with the affidavit, your lordship.
Hard miss.
D-Day lordship.
D-Dev.
D-Day.
D-Devi. Learned counsel for a petition. And Mr. R.R. Gogoi, learned planning counsel, public health engineering department.
All the respondent. Except respond number 2, all the respondent.
The petitioner has stated that he had executed a number of contract works. One or no, a number
Various
of
work orders.
works, for the respondent from health engineering department. As mentioned in the work orders annexed as annexer A. To the writ. The petitioner has claimed that against execution of the contract works, an amount of rupees 30,19,609 has remained outstanding, seeking a direction to the respondent authorities to release the said amount. The petition has prepared the instant petition. As Mr. Gogoi, no formal notice, extra copies. The learned counsel for the petitioner served a copy of the writ petition along with an excerpt to the Deputy Solicitor General of India for within 2 working days for service of notice upon the response number 2.
27-0.
The respondents will ensure that the counter affidavit is filed. Their response are filed on or before the internet.
Item 14.
Okay.
14.
Yes, madam. You are in a
Similar,
hurry.
lordship. Similar.
Similar order, 10,93,120. Respondents are same in CA team? Same. Same.
Same, except 2.
Synosis. I'll come back after 5 minutes.
Item 51.
May I please, your lord? This case, your lordship, there was a tender, your lordship, issued by the Indian Oil Corporation, lordship, inviting bids for bulk LPG transportation contract by road for the state of Assam and Meghalaya, lordship. That is at page 29 is the, your lordship, tender notice. Now, so far as the main tender notice is concerned, your lordship, that's, we have
Page 29.
page 29. Your lordship will find name of the work. And Other details are also there. But your lordship, we are more concerned with the corrigendum, your lordship. Now, if your lordship comes to the corrigendum that was issued on 4/4/2025, your lordship, at page 136. Now, if your lordship comes to page 137 of that corrigendum, there is some amendment in the tender notice, your lordship. And your lordship will kindly come to page 137, serial number 5, your lordship. They have added, your lordship, the last part, your lordship. In column 2, your lordship will find. In case of tank trunks, TTs, operating in the existing contract, your lordship, this is important, your lordship, existing contract. Many of the trucks are with them, your lordship, whose ownership cannot be transferred during pendency of the running contract. Your lordship will kindly note that, your lordship. And hence the formalities for transfer of ownership would not be completed. As on due date of the new tender, such vehicle can be sold through the agreement to sell. And both the seller and the purchaser have to submit affidavit as per the attached annexure 40 and 41, along with the valid registration document and peso license in the name of the seller. Then your lordship will kindly come to page 138. Second but last paragraph. In case bidder fails to submit the required documents with change of name, etc., within 4 months of issue of LOI, suitable penal action shall be taken, which may include EMD, forfeiture, caution money forfeiture, termination of orders such as TTs and blacklisting of such TTs. Under no circumstances will the above mentioned timeline be extended. In such case, the contracting corporation reserve the right and shall be at liberty to conduct duties as per the methodology mentioned in the tender to fulfill the shortfall arising thereof. Now, your lordship, from this, your lordship, it is that your lordship, they have given a 4 months time, your lordship, so that since tank trunks are already under contract, your lordship, and running through this IOCL, your lordship, and therefore, your lordship, agreement to sell will be enough. Not earlier, your lordship, that condition was not there. It will have to be in my name, the vehicles. So by agreement to sell, your lordship, I can offer. But only thing, within 4 months from the issue of LOI, I will have to transfer. Now, what has happened, your lordship? After this, your lordship, on 16/8/2025, that is at page 191, your lordship will find. They have extended the existing contracts for 2 months, your lordship. Page 191, your lordship will find it down.
Who is this Dipankar Sharma Bodole?
That is one of the earlier contractor, your lordship, earlier supplier of tank trucks, with whom we have, your lordship, agreement to sell, your lordship, these trucks. Now, these existing contracts were your
6 petitions.
6 petitions. Now, earlier contracts were, your lordship, extended by this.
Just a minute.
Lordship.
Petition number 1 is an individual.
Lordship.
Petition number 2
Lordship.
is a company, private limited
Lordship.
company. 3 is limited, I don't
Lordship.
know, company or not.
Company.
Common boy. Then this 5 is Messrs. So and so, proprietor.
Proprietor.
And Helen Form,
It is proprietor.
How can who signed? How can a company can allow
Lordship.
these 5, 6 petitioners are different entities,
Different entities, your lordship.
right? One petition number 1 has sworn the affidavit.
Lordship.
How can she file an affidavit on behalf of, say, for example, if it is private limited company, petition number 2,
Lordship,
Who needs a board resolution
Lordship,
to file a writ petition?
Lordship,
If petition number 3 is a limited
Lord.
company,
Lordship,
it needs a board resolution.
Lordship.
Whether this petition number 1 has been authorized by the board.
Lordship, so far as your lordship, it is concerned. Page 20, affidavit, your lordship may kindly.
How?
On being authorized by co-petitioner.
How can be company
Company
needs
can
board
authorize.
resolution?
Yes, lordship, there may be.
Where is that?
That I will have.
It has to be annexed. It must be annexed
Lordship.
in all cases.
Lordship.
How can it be otherwise?
Lord.
Multiple causes of action.
I can.
These are different causes of action.
No, ultimately, your lordship, they are aggrieved by the so-called notice, your lordship issued and the suspension order issued, your lordship. That's
Different
the-
suspension orders
different
perhaps
suspen-
individually.
Different suspension orders, your lordship.
How can the court, do you expect the court to deal with different suspension orders?
Your lordship, the point is one, your lordship.
Point may be one.
Single point, your lordship.
To us, the law, this can be dealt with one single writ petition.
Lordship, in my.
6 different entities.
Lordship,
1 individual,
lordship,
2 private limited
Lordship.
company, 3 limited, I don't know, company, 2 is director. So
Lordship.
definitely it's a
company, your lordship,
Then 4 is individual,
lordship.
5 is proprietorship firm, 6 is proprietorship firm, are of one common order.
No, your lordship, not common order, separate order, but the same point. That's a cyclo-style order, your lordship.
Right.
Ultimately, issue
But-
is one,
No, show me, Mr. Bhattacharya,
lordship.
the law.
Lordship.
That court can deal with this kind of writ petition in one single writ petition.
Your lordship, since issue is one, your lordship. in
Show
my-
me, I am not convinced.
But your lordship, it's a common cause of action, your lordship, because. your-
Common cause of action
Because your lordship.
does not mean different tenders submitted,
Tenders are
different bids
different.
submitted, different tank trucks submitted, different agreements perhaps for this four
Yes,
months,
yes, agreements are,
right? Then separate suspension order individually,
lordship.
right? Are of same date.
Yes, your lordship,
Let us see.
lordship. Same day to the suspension order. was.
Suspension from March 15th. Annexation.
Your lordship will kindly see,
Let us see one by one.
lordship, annexes 6, your lordship,
Page,
page 195.
Shruti Agarwal.
Lords. That is, your lordship, March 5. All are March 5, your lordship. And in fact, your lordship. It's by email.
Then same reply. Everybody,
Everybody has replied, your lordship.
no, same reply.
Same reply, identical reply.
So
Because
how
your
can it
lordship
be
issue is-
common, how can it be common cause of action?
Because your lordship will kindly see, your lordship, what I am.
Okay, well, you should notice
No,
the question of maintainability, which
I mean,
common cause of action will be examined on the returnable date in a very strict
Then
manner.
your lordship, I will do one thing, your lordship. rather
In a
than
very
taking-
strict manner.
No, your lordship, that is why I am taking instruction. Let me, allow me to withdraw this petition with liberty, your lordship will come by way of.
I think that is the,
Lords-
otherwise,
In fact,
whether,
I have
can you
done so, your
expect the court
lords.
to deal with,
Absolutely correct, your lordship.
otherwise it will be very
Lords.
difficult for the court. Every case is to be individually
Lord.
treated. You have entered into agreements with some other persons, every 6 persons with same person, no?
No, your lordship, agreement by the, with the company, your lordship.
Show us the law.
No, your lordship, I have already submitted, we will allow me to withdraw, your lordship. We'll file rather than taking this.
Otherwise, I am inclined to issue notice
Lord.
keeping the issue
No,
open.
that will not help us, your lordship, that's.
Counsel for the petitioners and Mr. M. Sharma and counsel for the respondent,
IOCL 23456, madam.
IOC.
Ajay
For
Falguni.
the respondent,
Ajay
IOC
Falguni.
authorities. Full stop. Mr. Bhattacharya has submitted that the petitioners be allowed to withdraw the writ petition with the liberty to file
এখানে আবার প্রশ্ন
individual writ petitions,
পড়াশোনা
AFRES. Efforts. First of, in view of the above submission made by Mr. Botakur, writ petition is dismissed on withdrawal, comma, with the liberty, comma, as per law. Otherwise, clubbing multiple causes.
Time being matter, item number 9.
I think affiliation is, where is Mr. Bhuya? The subject matter of the writ petition is affiliation of the petitioner college with the Bar Council of Petitioner Law College with the Bar Council of India. Which is, which is a subject matter, which is not a subject matter of bench for stop. The registry to list the writ petition before the appropriate bench.
Item 10.
May I please?
Huh?
Here in this case, my lord, petitioners are the.
How you are, how you are
My lord-
aggrieved?
my lord,
It is not
because,
yet,
my lord,
not
from-
yet done.
Yes.
From
Apprehension,
apprehension that
mere apprehension
apprehension.
without any substance.
Apprehension on that count, my lord, they will cover up.
If we go on apprehension, Mr. Alam will say that this man is trying to kill me. Writ petition.
My lord, may I have also submitted a presentation, my lord.
No, this court does not give this consider jurisprudence. This court does not allow consider jurisprudence.
In such cases, my lord, your this honorable court also passed a order by lord on 13/9/2013.
I'll distinguish.
No.
I'll distinguish.
Let the cause of action arise, then he can come.
There is no cause of action.
And since there is a requirement of obtaining government prior approval from the government as page 40.
If something goes against the policy or any statutory provision, that's okay. But simply because somebody is going to issue a fair price shop license in and around the area, that cannot be a ground.
No, my lord, we are not challenging their license, my lord, but we are apprehending
License
that
is yet to come.
the consumers may be deducted from our fair price shop, my lord. That is our apprehension.
It is a
my lord. That is
government
our-
policy. It is dependent upon government policy. How can you be aggrieved based on it? Where is the reverse? Apprehension.
No,
Apprehension. Okay.
My lord, we have also mentioned the name of the persons that concerned, the name where names were issued, license were issued, my lord.
Maybe.
License have been issued.
Maybe, my lord, even then, my lord, for the
Licenses have been issued. Licenses have been issued.
My lord, for longs, their names are in our representation, my lord, but we have not received the copies of the license, my lord.
Even then, my lord, even if license can be issued, my lord, but it is for the benefit of the beneficiaries.
What legal right?
Yes.
What legal right is infringed? You don't know license have been issued or not.
That part I am not disputing.
Yes,
my lord, but-
after issuance of license, you may say that, yes, my consumer should not be,
Deducted.
but that has not been happening. You are running your fair price shop
My lord,
as on that smoothly.
my lord.
if something in a
Happens.
government document, if there's something in a government document appears, yes, wherefrom a genuine apprehension has arisen. Right, okay. But here, simply making an application, don't issue licenses to them. And that cannot be a cause of action.
My lord, I have also mentioned at paragraph 5, my lord, of my reputation, my lord, regarding the our show at population wise, my lord, page 8, my lord.
No, is it been affected?
No, my lord.
No. Then don't find anything.
648.
Page 5, my lord,
I have seen your table.
my lord. And there are only
Don't
600,
jump the gun.
600, 800 and 700, my lord.
Jumping the gun.
My lord.
You know jumping the gun.
I-
Have you run a race
No, my lord.
in your school or college?
In college, my lord, that's a different.
Huh? Before the referee starts, you start running. So jumping the gun, this is the case of jumping the gun, petitioners. I am dismissing it.
But in that case,
Closing all.
I may be allowed to withdraw this, my lord.
Better.
With liberty.
Don't start running when the gun is fired.
With liberty, my
No liberty.
Not my lord, because cause of action.
There is no cause of action.
Why my learned friend has been contacted
I'm
by the
I'm not.
Then we have
No.
lordship, my lord.
To stop the flood of premature petitions. This is premature. Heard Mr. I alum learned counsel for the petition and Mr. Miss U Das learned additional senior government advocate Assam. Post of after hearing the learned counsel for the parties at some length, Mr. Alom learned counsel for the petitioner seeks liberty to withdraw the writ petition. Six to withdraw the writ petition, come out with liberty to file afresh in the event of any subsequent cause of action arises. Full stop. Right?
My lord.
In view of the above submission made by Mr. Alom, the writ petition is dismissed on withdrawal with liberty as prayed for.
Public.
For admission, item number 15.
Yes.
Regarding granting of country spirit license.
Country.
In a existing IMFL license, my lord.
IMFL to country.
No, no, there is a IMFL license.
You want to add on?
Add on, my lord.
Sir, Lordship, we have received the instruction, Lordship. Petitioner wrote a letter to Superintendent of Excise that he will withdraw the case, Lordship.
Take your instruction.
That instruction I don't have. It's my learned friend has told me, my lord.
Conindo Colita.
I'll contact with my client, my lord.
Hi, Mr. N.J. Khatuniya, learned counsel for the petition, and Mr. N. Goswami, learned standing counsel, Excise Department for the
All the respondents.
for all the respondents. Full stop. Mr. Goswami has submitted that the petitioner has submitted an application on 2/3/2026 before the respond number 4 seeking mentioning that he could withdraw his writ petition, the present writ petition, seeking additional country spirit license. Post of, in view of such submission made by Mr. Goswami, Mr. Katani has sought for a week's time to obtain, to complete his instruction. Post of list as prayed for by Mr. Katani, list that keeps on so and so.
After 1 week,
Yes, after.
1 week. Okay. Oblig.
Did
23rd March, 2303. Item 17.
Lordship, in this case, we are filing the additional affidavit during the course of the day. Already copies has been served.
Okay. Mr. F.L. Oscar, learned counsel for the petition is present, and Mr. S. Doctor, standing counsel revenue department for the respondent 1 and 2 are present. Mr. S.R. Burrow, learned junior government with Assam. Appearing for the respondent 3, 4, and 5. Has submitted that the additional affidavit in deference to the order dated 12/12/2025 is going to be filed during the course of the day by supplying a copy to the learned counsel for the petition. So, in view of the above submission, let the case be listed on so and so with the additional affidavit if filed, comma on record.
2503.
Obliged.
Item number 18.
Where is the previous order in the petition?
Malata, previous order is,
Page 67.
yes. Start from page 66, minute.
Six.
Okay, thereafter you submitted it, copy.
Yes, minute. But nothing has been done.
Now they have filed affidavits.
Yes, affidavit
Let
filed.
us see
Malata,
the affidavit first. Affidavit
kindly
response number
just
4.
peruse the last order dated 17/11.
Let us see the affidavit.
Yes.
Response number 4.
So the only para 5 minutes.
Para 5
Yes.
admitted.
Yes.
Deputy Commissioner admitted.
Admitted.
Then what is the next
And
affidavit?
then Malata, the commissioner has
Then we
filed.
have
an
filed
affidavit.
our affidavit.
The commissioner stand is that they have not received the original vouchers and bills from the deputy.
Let us see his affidavit.
But page 90,
Delete Botras.
starting page 90 minute,
On behalf of Swen.
para 5.
Commissioner filed the affidavit when? 6 February 2025.
Yes.
that verification process is still pending.
Acha.
After
Yes, sir.
verification, commissioner will submit proposal.
Lots.
That is in February 2025. Then what is 17/11/2025 order?
Then after we again,
17/11/2025.
Yes.
So para that thereafter affidavit was filed by Deputy Commissioner.
Filed, then last order, 8/12/2020.
Just a minute. He said about on 5 occasions he sent the
Yes,
report.
yes.
Letter received from so and so.
Now due to their communication gap, petitioner is suffered.
Then the commissioner has filed any affidavit.
Lordship again, we have filed our affidavit.
Pursuant to the order 17/11/2025. Okay, file,
This is
file.
filed on 31/2020.
Said letter. দিবলে দিছে যদি দিয়ে তেতিয়াও the company with the declaring functions without certifications. Without certificates, certifications from the competent. Into file.
Yes, after 8/12/2025, what are your instructions?
I have not received any instruction, but my learned sister has received some instruction. That's what he has provided me to.
We have already again sent a letter to the district commissioner for submitting the certified bills vouchers.
Let the chief secretary come in picture. Government must speak in one voice. Different authorities under the government cannot speak in different voices. Finance department saying reject every time, 4 times, 5 times. Panchayat or what department? Panchayat. Panchayat saying we don't agree. Deputy Governor said, I have forwarded. Chief Secretary party. This is not the way since 2012. Is a party?
Principal Secretary's party.
Usap ki হৈছে গম পাইছা নে? Idea
Let Principal Secretary Panchayat Department. I staff it.
Let's say now principal.
No, you wait.
Additional chief secretary is, principal secretary is not in the post in the principal, Panchayat and Rural Development Department.
Principal
Additional,
Secretary, there is no Principal Secretary.
no.
No
Additional
principal
chief, additional chief secretary,
No Principal Secretary nowadays.
lordship.
Huh?
No lordship, now it's additional chief secretary.
Okay. Mr. Islam, file by tomorrow, amended cost title, will make him additional chief secretary party. Then he should
Yes.
file the affidavit.
Yes,
This tug of war cannot go on,
yes.
right, Mr.
My lord, because we again write letters, we don't get any.
We are not inclined otherwise, but sometimes principal additional chief secretary should come, thereafter chief secretary should come. Otherwise, these authorities are playing ping pong.
That is
Heard Mr. R. Islam, learned counsel for the petitioner. And Miss Ann Bora. Standing counsel, Panchayat and Rural Development Department for the response number 1, 2. Miss AB or AB. NB, Nogam, NB Casto. Yes, what do you say? No affidavit from your side. It is your work.
Yes.
Yes.
It is your work.
Panchayat.
You have extracted work from him. Again, you'll be extracting work from him. For the RDB Standing Council Election, Assam State Election Commission for the response number 3. And Ms. Yudas Planet Additional Senior Government for the response number 4. Post of different the respondent authority, the authorities in the responding authorities. That is the response number 2 on one hand, and the response number 4 on the other hand, are taking seem to have taken conflicting stance in their affidavits filed in this state petition. First of, this court will judge of you that the departmental head in the Panchayat and Rural Development Department would be the appropriate authority would be the operator who should file an affidavit in the matter, full stop. The respondent number 2 and 4, respondent number 4 are different authorities of the state government. And before the court, comma, the state government must speak in one voice. In such full stop. Ms. Bora, Standing Counsel. Panchayat and Rural Development Department has submitted that presently, comma, there is no post as Principal Secretary to the Government of Assam.
Additional Chief Secretary.
In the Panchayat and Rural Development Department. And the department is headed by the Additional Chief Secretary to the Government of Assam, Panchayat and Rural Development Department. Post of Para, Mr. Islam shall submit an amended cost title to impede the departmental head of the Panchayat and Rural Development Department. By tomorrow, raise the case on submission of the amended cost title. There is to carry out the necessary correction and the cost title as well as in the CS to stop raise the case on next Wednesday. In the meantime, the respondent number 3 shall file its counter affidavit.
But 18-3. 18-1-8. 180. Item number 19.
For the petitioner, my lord. On the earlier occasion, the respondent number 3 is directed to produce.
Affidavit is ready, my lord. That I would like to file it today.
Or otherwise,
Claim
not
is, my lord, regarding some, my lord, subcontract, my lord, issued by the prime contractor. And he was engaged by that subcontractor. Now, my lord, claim has been made for arrear wages from the PW department.
A labor officer has wrote to the chief engineer,
My lord.
right? Then chief engineer wrote to the executive engineer to make recovery.
The recovery part, my lord, when the contract was already over.
No, but he said retain 9,32,000.
No, that is for, my lord, for non-completion of the work in time, my lord, that penalty was imposed, not on this point.
Recover had been recovered. He said, come to the letter. Come to the letter.
Lordship.
Where is the chief engineer's letter?
Well, that will clarify in affidavit. That is, my lord, for non-completion of the work, that penalty was imposed.
No,
from the SDM.
Where is that letter? Where is that letter in the case record? Where, madam?
And sir, E page 25.
E, page
Page?
25, yes.
Page
25.
25. 25. $9,32,245 is recovered from Gambaru,
My lord.
right?
Lordship.
This is a statement, office order.
No.
And where is the chief engineer letter?
Chief engineer.
Previous page. To the chief engineer,
No, my lord.
please recover 19 lakh.
And lordship will see page 16 for a moment. What was the claim before the labor officer?
That I know, but
No, just, my lord, whether that will cover this entire amount or not. Lordship will see page 16. First one is, my lord, higher charges for JCB. Check and, my lord, 2 tipper for 10 months. 21 lakhs, another is 4 lakhs, 50,000. This will go, my lord. Cannot be under the, my lord, labor law. Wages of the staff, my lord, 51,000, 72,000 and 72,000. So this other part will not come in, well, for JCB and tipper.
now what has happened to the recovery amount?
Affidavit, they say, my lord, this is for.
Because it is in reference to labor officer's letter.
My lord.
It page 25. It is in reference to the labor officer letter.
Now, my lord, challenging this particular letter, A writ petition is pending, my lord.
Right, you say that.
Yes, sir. Challenging this particular letter of the executive engineer at page 25, a writ petition is pending, my lord. That's,
And challenging page 24,
yes, my lord.
24 also.
No, only, my lord, that executive engineer's letter, whereby, my lord, 9 lakhs was, my lord.
By whom?
By
Number-
the, my lord, main prime contractor, that is
Number-
Gauhati, yes, that is, my lord, WPC number 36 of 19. So it may come together, my lord, both the writ petition. In the meantime, I file my affidavit in this case. By today's
WBC number 19.
36 of 2019.
Otherwise, the claim is the manner in which that
My lord.
amount is claimed, that is doubtful.
Doubtful,
But
my lord.
question is that there is an office order, labor officer's order, thereafter chief engineer's order.
But my lord, lordship will see,
recovery.
my lord, nothing is there to show that, my lord, there was some agreement, though they have statement that there was a agreement.
That I know, but.
And my
it
lord,
is
that
the-
master servant relationship, my lord, is severed. Moment, my lord, that contract is over. It now in 2015.
Look, but
And there are-
your letters,
And probably, my lord, going by that letter.
you are instructed properly by law,
Lordship,
chief engineer, executive engineer.
my lord.
We cannot assume that they do not know the law.
I understand, my lord.
The
But
labor officer,
yes,
he
yes,
has passed an order, I don't know for what reason or,
My lord.
but he stands as on it.
lordship.
That is why
Yes, yes.
otherwise I am not
Because, my
very
lord,
convinced
this-
about the manner in which they are
Yes,
claiming.
JCB, my lord, how it will come in under the labor law, my lord. JCB, people.
Otherwise, I am not convinced, but because of your orders, you made the recovery from the contractor.
9 lakhs was.
Chief engineer said, recover. Executive engineer says, I recovered.
That's it.
Thereafter, what happens? It is since 1900 to 2000,
2015, my lord. These are
15,
2015.
10 years.
10 years.
And you are sitting over that money after recovery. This is not done also. What Ms. Ripuri, learned counsel for the petitioner, Mr. B. Google, learned standing counsel PWD for the response number 1, 2, 3, and 4. And Ms. Udas, learned Union Government of Assam, also additional city government of Assam for the response number 6.
The labor taking over.
Full stop. The response number 5 is absent. Again.
The dispute is not.
Despite service of notice. Full stop. Mr. Gugoi
Well,
has submitted that the affidavit, an affidavit in reference to the order dated 25/2/2026 is going to be filed during the course of the day.
well,
And therefore, command order for personal appearance would not be necessary. Full stop. He has further submitted that another writ petition, WPC number 36/2019, connected with the issues involved in this writ petition, is pending. And the said writ petition be also listed along with the instant writ petition. Full stop. As an affidavit is going to be filed during the course of the day, as submitted by Mr. Gogoi, no order for personal affairs of the response number 2 is required as on date. Full stop. Release the case on so and so date.
23rd March, 23rd.
well,
Along with the writ petition, along with WBC number 36/2019
well.
and the affidavit. If any, filed during the course of the case.
Bless me.
Yes, Mr. Dotto. Next case.
item, yes,
Next case.
They seek time.
Yes, Mr. Deputy.
Lordship, I have received the instructions. I am praying for 2 weeks' time to file my response, Lordship.
Only,
No availability is fine.
only request, my lord, that this is a subsidy matter. On the next date, endeavor may be made, my lord, to dispose the matter.
Yes, yes, yes.
That we'll try always.
Yes,
but
yes.
No affidavit comes.
22nd.
No clarity.
If such an order
we
passed,
cannot,
then
we
Mr.
cannot-
Chaudhary may.
We cannot kick the, in, which confusion. Heard Mr. B. Dr. Senior Counsel, listed by Mr. S. Dekal, learned counsel for the petition, and Mr. R.K. Devchowdhury, learned Deputy Solicitor General of India, for all the respondents.
Yes, Lordship.
Post of Mr. Devchowdhury has submitted that he has received the necessary instructions to file the counter affidavit. And given 2 weeks time, the counter affidavit will be filed. He has thus sought listing of the case after 2 weeks.
After,
The prayer made,
may I request, madam, on 22nd after view, the matter may be fixed.
okay, the prayer made.
Meanwhile,
Okay. Then 3 weeks.
Then
Okay,
meanwhile,
3
then.
weeks.
So
Even 3 weeks.
magnanimous of my.
The prayer is made by Mr. is accepted. Release the case on Swans.
20.
Item 23. I am paying for Mr. Ayataka, madam.
I have filed the affidavit, my lord.
In item
Today.
23, madam, the government has filed the affidavit, madam. We need
Today.
some time, madam, to file reply, madam.
We have filed affidavit today, man.
Okay, Mr. S. Watergood, learned counsel for the petition. Heard and Ms. Udas, learned petitioner, the new government for the state response. Post of Mr. Das has submitted that counter affidavit on behalf of the state response has been filed today. Come on, which is not part of the record. Post of Mr. Watergood, who has received a copy of the counter affidavit, has sought for and is granted how much time?
For 3 weeks, madam.
3 weeks. What more are you guys?
But this is regarding my cancellation of PDL license.
3 weeks time to file a reply. Release the case on so.
2404.
So far, madam, 25, 26 and 27, madam.
28.
Oh,
You will be arguing.
6 April. 6/4.
6.
So far, madam, 25, 20, 27, madam, the
Ah,
readings are completed, madam. It may be tagged with serial number.
this one.
25, 26, 27, madam.
Okay. 25 the book as sought for by Mr. Watergood, learned counsel for the petition, Ms. Udas, learned physician, senior government, of state response. Have submitted that exchange of pleading is complete. As sought for an eligibility. Parties raised the case on same date.
Yes, madam.
Okay, same.
And then 20th, 30, madam, the government has filed affidavit, madam. We need similar time.
28?
And 30, madam.
Okay, 28 PKD, same that we do.
20 and 30.
So 23, 25,
Yes, madam.
26,
26, 27.
27,
Yes,
28,
20,
30.
30,
30.
30, madam.
20 or 30, the affidavit in reply.
Yes, madam.
Bottom by item number 23 is the. Okay.
Obliged.
29.
Made visible.
Which was this matter as per order dated in April 2025, the respondents were required to file an affidavit. That is not.
J. Goswami. Who, Miss J. Goswami appears for whom?
Lordship, that appeared for the petitioners. We were about to file an additional affidavit.
Yes.
That is for only in respect of the authority that has been given to the present petition. Lordship, we will bring.
Have you
on that.
filed?
Not Lordship, we will file Lordship. We have received the instructions and.
Mr. A. Betala, learned counsel for the petition. That's sought for listing of the case after
Lordship, of 2 weeks.
2 weeks, file the additional affidavit as sought for as opposed to Miss Udas.
I'm for 1 and 6, madam.
1 and 6 is present. Very loud, place the case on so and so.
Obliged.
Item 35.
Wait, please, Your Lordship. Also, the petitioners in this case attempted to take notice through Dusty, but the respondent number 3 and 4 declined to receive, but they have already filed their Wakalatnama in this case.
Is it?
3 and 4.
Their names are reflected?
Yes, Lordship.
Nobody is present. Who are respondent number 3 and 4?
Titapur Municipality Board.
Oh.
And,
Okay, let's one such be given them to them.
Lordship.
Mr.
US Bora.
Bora, US Bora, learning counsel of the petition, and Ms. Udas, learning relations, senior government advocate. For respondent number 1 and 2 are present, though the name of the respondent number, though the names of the learned counsel for the respondent number 3 and 4 are shown in a cause list, indicated that the respondent number 3 and 4 have entered appearance. None is present when the matter is called to stop. Let the case on also justice be again listed on next to the video.
So let me give. Lordship. Lordship.
Item 36.
Lords, I am led by the senior advocate who is online, Mr. Ashish Mohan.
Also, that production item will also be taken up along with this, that the file is before the court.
Okay. Aisha ne?
वो देखना ज्वाइन किया आशीष मोहन.
Production is item 1.
Yes.
आशीष मोहन के नाम से ज्वाइन करो. It's unloaded.
जल्दी से जल्दी व्हाट्सएप किया
मेरे पास है सब कॉपी.
Yes.
May it please your lordship, with the permission of the court and permission of the learned counsel, senior counsel lordship, I'd like to bring to the notice of the court lordship, we've issued the LOI in respect of the lowest bidder, your lordship. Lordship, this is, and the same has already been uploaded, lordship.
Yes.
Yes, my lords, I am led by Mr. Ashish Mohan.
Ashish Moore. Ashish Moore.
My mic. Unmute, sir.
May I address the court now? Lord, this is a case where in the first round, in the first writ petition, your lordships were, my lord, pleased to pass an interim order permitting us to participate. That interim order, your lordships will, my lord, find at page 64 of this writ petition.
Yes.
27th of February 2026. Lord, the scope of that writ petition was that the eligibility criteria, which according to us was tailor-made for certain bidders, was challenged. In that challenge, your lordships, my lord, were pleased to pass an order. And please just see, my lord, right at the end, page 67, paragraph 11 and 12. I don't want to trouble your lordships with the submissions, etc. Just have a look at the operative portion, paragraph 11 and 12. On receipt of information about extension of time for bid submission online, Mr. Chaudhary, learned senior counsel appearing for petitioner, has submitted that the petitioner will submit its bid online on or before the last date of submission of bid so extended. Such submission of bid by the petitioner without prejudice to the petitioner's right to challenge to the eligibility criteria on the ground of their onerous nature. Since the last date of bid submission has been extended, the petitioner is at liberty to submit its bid online on or before the last date of bid submission so extended. The issues raised in this writ petition are subject to further consideration of this court. Now, therefore, my lord, your lordship said, please participate and we will see whether the tender conditions are exclusionary or not. Now, please see, in this writ petition, Lord, pursuant to your lordship's order, we participated along with 3 other bidders. Now, there is an evaluation criteria which is contained in the tender document itself. That evaluation criteria, your lordships will not please see page 39 of the paper. Your lordships have 39? Yes. Lord, this page 39, there is a technical evaluation matrix in 20.3, and your lordships will not find that so far as numbers 1 to 4 are concerned, they are objective criteria, and number 5 is a subjective criteria. The first one being, what is your cumulative turnover in the last 3 financial years for 2022, 23, 23, 24, 24, 25, and the basis of evaluation is also given to be that if you have a turnover of 120 crores to 150 crores, then you will get 10 marks. If you have above 150 crores to 200 crores, you will get 12.5 marks. And similarly, if you have above 200 crores, you'll get 15 marks. So it's as objective as can possibly be. I simply have to show them the balance sheet, the numbers. If I qualify, depending on which criteria I fall in, they will give me either 10 marks or 12.5 marks or 15 marks. It's as simple as that. Similarly, your lordships will find, my lord, number 2 and 3 and 4. These are all, my lord, objective criteria. In 2, if I have a minimum net worth of 70 crores, then I will automatically get 10 marks. It's as simple as that. Similarly, number 3, if I have installed 40,000 cameras or more, I will get 15 marks. And in the 4th criteria, if I have more than 200 manpower, I will get 10 marks. Number 5 is an approach and methodology issue, which says that for a project management plan and methodology, you can get maximum 30 marks. And team deployment plan, you will get maximum 10 marks. And last, for a demonstration and streaming of the cameras, you will get maximum of 10 marks. So here, of course, the state has retained a subjectivity to itself, saying that, look, I will allot the marks based on your presentations, etc. Now, that, of course, my lord, cannot be subject matter of judicial review. I will not go into that aspect. But on the first 4 aspects, your lordships will find, Lord, that these are completely objective. It's an evaluation of numbers, nothing more. So far as the first criteria is concerned, Lord, which is above 200 crores turnover, your lordships will not please just have a look at page 69. I, my lord, submit a CA certificate which shows on the extreme right hand side column gross annual turnover. In the gross annual turnover, your lordships will find, my lord, first year I had 359 crores. Then I had 614 crores and then 763 crores. So in each circumstance, more than 200 crores. So automatically I should get 15 marks. It's as simple as I showed your lordships. Similarly, my lord, coming back to the eligibility criteria, I would request your lordships to hold page 46, my lord. I'm so sorry, page 39, because I will have to take your lordships back to that page. So far as the first criteria is concerned, therefore, I was entitled as an objective matter to 15 marks. Similarly, for the second criteria, if, my lord, I have a net worth more than 70 crores, I get 10 marks. Now, just come back to the same page 69 again. The second column, my net worth is 156 crores, 353 crores, 564 crores. So in each case, more than 70 crores. So again, I should get straight away, my lord, the marks which I'm entitled to, which is, my lord, 10 marks straight away. For the third criteria, if your lordship will just come back, page 39. As per this, if I have installed, my lord, more than 40,000 cameras, I get 15 marks. For this, my lord, please peruse page 72. My lord, about the 8th row from the top of the page 72. First one is, my lord, provisioning of servers, etc. Just in that, just come to the last one. Number of locations to be covered. 82,000. So, my lord, I have installed 82,000 cameras in a previously held election. So more than 40,000, automatically I get, my lord, those marks again. The last criteria, the objective one, my lord, if I have more than 200 manpower, I get 10 marks. Now, for this manpower, just kindly come to, my lord, page 87. This is my employees' provident fund to show how much manpower I have. And, my lord, right on top of the page, I'm sorry, this is possibly landscape, so consequently, your lordship will have to read like that. Please see establishment code so-and-so, establishment address, and then please see total subscribers. Total subscribers being 601. That's more than 200. So, my lord, on all of the objective criteria which are set out in the tender, I get the maximum possible marks because this is objective. There's no way that they can say that, no, look, in my opinion, you should have got less. There's no matter of opinion. It's a matter of fact. On a matter of fact, therefore, I should have got 50 marks. Somehow, while, my lord, evaluating the tender, they have given me only 33 marks, which, my lord, is impossible. So therefore, my lord, my case is one that at the very inception, when I came to your lordships with the first writ petition challenging the eligibility criteria, I set out a case that, look, this is tailor-made. This is in order to favor certain parties. Now that, my lord, is compounded by the fact that when they evaluate my tender, pursuant to your lordship's direction that let them participate in the meanwhile, they give me on an objective criteria, they give me 33% marks. Whereas I can establish on papers alone that I had to get 50 marks. My lord, I could not have had any grievance before your lordships had they said that, look, for this I am giving you 50 marks, but for the subjective criteria, I will give you 5 marks, 10 marks, 15 marks, whatever it might be. But here is a case, my lord, how did they objectively come to this conclusion? It is impossible. For this, may I just show one last document, and, my lord, that
Evaluation
is
on page 89, my lord.
page
89. 89, my lord.
89, which is, my lord, the evaluation sheet. only 4 tenderers participate because, as I said, my lord, as it is the criteria was tailor-made. I'm the one who had an interim order, therefore I was allowed to participate. Please see, my lord, I am at number 2, Innovative View India Limited. Maximum technical marks 100, technical marks obtained 33.9. Now they must explain how did they give me 33.9? I have shown your lordship, lord, objectively I had to get 50 at the very minimum. And then they had to evaluate the subjective criteria. Based on the subjective criteria, they could have given me 5, 10, 15, whatever it might be. That's a different matter. But it appears that there is something afoot to somehow favor a certain party. Especially in view of the fact, my lord, that I am instructed that so far as the qualified bidder number 1 is concerned, he has previously been blacklisted by a PSU. Of course, I'm also instructed that there is possibly a stay, so I can't go too far into that aspect. But it is number 3 who has now been, my lord, awarded the tender on 91.3 marks. But, my lord, if I had to be evaluated, somehow, my lord, the first bidder gets 90.3, the second one gets 91.3, and the other 2 bidders are 33.9 and 27.3. I fail to understand this, my lord, strange evaluation criteria that they have followed. Perhaps your lordships will not have to call for the tender records to see as to what went into the mind of the authority. Beyond that, of course, in a tender matter, I'm aware, my lord, I can't ask your lordships to go beyond the point. Which is why I concentrated, my lord, on the objective criteria. I didn't go into the subjective criteria at all.
How did you evaluate marks?
It did. Lordship, if I may furnish a copy of the corrigendum, Lordship. One minute. Lordship, why this corrigendum, clause 20.2 was revised, Lordship. It was uploaded in the system, Lordship. In the 4th column, Lordship, is the revised text. If I may read, your Lordship. Yeah, can I give you an online copy? Yes. Lordship, the last part in the 4th column. Only bids that are found to have met the minimum eligibility criteria shall be eligible for detailed technical evaluation as per the evaluation metrics provided in clause 20.3. Lordship evidently admitted fact that they have not met all the eligibility criteria. That's why they've come before your lordships for relaxation and for
What is that matrix? Was 20.3.
matrix is at page 39, your lordship. The marks that are being referred, your lordship, in paragraph, if I may come to point 3, your lordship, of the matrix, your lordship, 30,000 cameras, 35,000 cameras, Lordship, we have to correlate them to the criteria, Lordship, minimum eligibility criteria, which your Lordships will find in on page number 32.3. Lordship, only after these criterias are met will the question for evaluation of the technical part will arise, your Lordship.
But why did you evaluate it?
Lordship, they were called, there were only 4 bidders, so we evaluated all of them. Lordship, but first the minimum eligibility criteria has to be met, your Lordship.
They'll
Place the mark sheet
Lordship, I may,
tomorrow.
Lordship.
Let us have the mark sheet.
Yes,
Very
sir.
well. Very well. We'll come back to it. No difference.
Unless we were granted liberty under the orders of this honorable court, my lords.
That's right. So in that
Right.
case,
But
they're
there is-
overeating the order, my lord, if that's the case.
Yes, yes, my lords, my lords.
I just want to point one thing, your Lordship. Page 89, your Lordship. Lordship, this evaluation report was communicated to them on 6th of February. Lordship, they could have approached the authority asking for clarification, your Lordship. After the bidder has been selected, Lordship, they again come here
My lord,
contesting.
because the matter was
challenging-
pending before this honorable court, they did not crave the leave of this honorable court for issuing the said order. My lords, they are in such a
Lordship.
hurry. My lords, they have issued the letter of intent.
Lordship, we must be at war footing, your Lordship. The elections are coming, your Lordship.
My lords,
So far as time is of essence, otherwise the matter is time is of essence.
my lords,
And there is no stay in the earlier order, your Lordship.
Okay, give the marks.
Lordship.
How you have evaluated and arrived at the figure 33.9.
Lordship.
Let us come back tomorrow and address your lords. Please.
Okay,
Most back.
A artist mode and senior to virtual mode, with Mr. Your name,
Anuj Saxena, Anuj Saxena.
Learned Counsel for the petitioner, and Ms. S. Kotoki, and Standing Counsel, Election Commission of India, to the responding number 1 to 3. 1, 2, and 3.
One is union, your Lordship. if I'm-
One only.
No, Lordship, 1, 2, 3, your Lordship.
1, 2, and 3, and Ms. Huda. Learned additional senior government for the respondent number 4. The petitioner has highlighted that as per the technical evaluation report -2 issued by the respondent number 2. The technical bids of all the four participant bidders were evaluated to the technical evaluation metrics set forth in clause 20.3 of the bidding document. First of, it is contended that if the objective criteria laid down in serial number 1 to 4 in the technical evaluation metrics are looked at vis-a-vis the documents submitted by the petitioner in support of such criteria which are objective. The petitioner ought to have been awarded 50 marks. First of, Mr. Moore, and senior counsel appearing for the petitioner has submitted that by no stretch the petitioner could have been given marks 33.9 marks against such objective criteria. First of Ms. Kotoki, and it For further consideration from Ms. Potokil and its standing counsel, ECA shall produce the breakup of marks given the technical evaluation report. Full stop. List the case tomorrow.
Lordship.
Well, it's in the motion column, my lord. Motion column.
Definitely motion column, I have not issued notice.
Very well. I'm glad.
Obliging. Good.
Whatever the other, it will release the case tomorrow.
Lordship, in the last item, Lordship,
This item number 36 also.
Lordship,
36 also.
Lordship. With apology, Lordship, item number 35, 35, Lordship. I was missed the item, Lordship.
So I have granted you liberty. I have just said that because of your absence, let the case be listed again in the next week.
Lordship.
Supplementary list, item 52.
Yes, my lord, I have found out that missing paragraph 56, Lordship was searching for.
56.
My lord, initially when we took printouts from the.
Order is June 3, 2022.
Yes, madam.
T.N. Godavaram.
Yes. Madam,
Right. Thereafter, April 26, 2023. And some other orders are annexed to the writ petition. That those are also arising out of T.N. Godavaram?
T.N. Godavaram.
Okay. T.N. Godavaram. Just.
Yes, yes, madam.
Now here, so far from there, maybe it is 10 kilometers. Let us, for a moment. Then as per DFO's report, you are beyond 10. As per DFO's report, you are beyond 10. Now, here, page 68. Page 68. Page 72. This is an order of 2019. What is this? What is the significance? Kaziranga National Park illegal mining. Then certain matters are apparent from the record following as page 72. Now,
yes, page 72 has
page 72 of your writ petition.
Yes, so page 72 is a order dated 12/4/2019.
19.
Yes,
right.
that order has attained finality on 20/11/2024. That order is at page 76.
Let us understand then. Which part, page 76?
76. 70 is.
It starts at page 74. It is dated 20/11/24.
There is a elevated corridor approximately Senator's proposed. Project includes progress.
Page 77.
Now, paragraph 5.
Yes.
What is this? In the affidavit filed on behalf of AAAC, 5/11/2000.
If your lordships kindly have a look first at page 74 for a second. 1, 2, 3, 4th line, you know. After all these numbers.
Yes.
In illegal unauthorized mining in Kaziranga National Park, Assam, Milord, we have to understand this is something to do with a situation which prevailed in 2019 and prior thereto, where there were illegal mining activities. That was brought to the notice of the Supreme Court. The Supreme Court has passed the first order, which your Lordship has seen at page 68, and directed that illegal mining should be stopped. Then, Milord, the 78 comes. 76, I think.
Up to paragraph 4, it deals with elevated corridor.
Correct. So it is now 74. It is 2011-24. This is, the earlier order is of 19.
Yes.
Now,
Just 2411.
yes,
2011, 2024.
2011-24. That starts at page 74. Then at page 77, Milord, that elevated corridor thing has gone.
Paragraph 5.
5 is the concerned thing. In the affidavit filed on behalf of KAC, dated 5/11/24, it is stated that all mining activities inside Karbi Anglong district bordering southern parts of Kaziranga National Park has already been closed pursuant to the meeting of the CEC. It is further stated in the affidavit that notice to close 33 stone quarries and 18 numbers of stone quarries as well as 18 stone crushing units was issued. It is further stated in the affidavit that the mining activities along the southern boundary and catchment area of the river and stream originating in Karbi Anglong has already been prohibited by order dated 4/5/2019. That's the order passed by the Deputy Commissioner Karbi Anglong. The affidavit also places on record a letter dated 7/5/24 issued by the Divisional Forest Officer at KHE, stating that no new order for lifting the closure of the quarries has been issued. We therefore find that KSE has also taken necessary steps to stop the illegal mining in the areas bordering KNP. We therefore close the proceedings insofar as these two issues are concerned. Therefore, my lord, the first order is of at page 68. That was of
2019.
19. At 68, my lord, 12/4/19. At page 69, serial number 7, it was taking up that application for illegal unauthorized mining in Kaziranga. My lord, that was a situation which prevailed during that period where there were a lot of mining activities without proper permission. Therefore, the matter was brought to the notice of the Supreme Court. Supreme Court first passed the order into 12/4/19, directing that you have to remove that. And the Assam government filed that affidavit in 24, which your lordship has seen at page 77, and everything was stopped. And that report was given by way of an affidavit. And the Supreme Court therefore closed that chapter. We are not concerned with that chapter at all. Your lordships have gone through the first initial orders, where your lordships find that the DFO himself is writing now. So far we are concerned, my lord, to the director, mining. If your lordships kindly have a look at those two letters, page 44 and 45, no?
Because we are relying on this from
And this is, my lord, this particular case, it's a periodic patta land. The person concerned is the private owner of that land. And he has given a proposal that he wants to do the mining, and which is contemplated under the Act and the rules. And therefore, they examined the whole matter and then they proceeded with that and allowed us to do that mining. Page 45. Before that, if your lordships kindly have a look at page 31 also. To 132. No? Your lordship, just have a look at page 30. In fact, my lord, if your lordship first look at page 28. This is from the Chief Conservator of Forest to the Divisional Forest Officer. Settlement of PP land, stone quarry so-and-so under this range. KSC later dated so-and-so. And closely signed herewith, case is later under reference to the above subject, the contents of which are self-explanatory for your information and necessary action. The operation of Patalan stone will be allowed only after observing all the formalities and fulfillment of necessary requirements and clearances as required as per existing rules in force. However, the operational period of permit is restricted to 2 years, which reduced quantity of 30,000 cubic meter. The depth of permissible stone operation is 1.5 meter and royalty is 1.5 meters times the existing rate of royalty as per the provisions of the Assam Mineral Concession Rules to 2013 amended 2018. So these have gone from the Chief Conservator of Forest. This is below in 21. So this is a completely legal process which has been initiated. And then if your lordships kindly have a look at page 29. No?
Yeah, I have looked at earlier.
Yeah, your lordship has seen.
Now, page 52 is the impugn one.
Yes, yes.
Now, it says about proposed eco-sensitive zone, right? And so far, the two detail order in Godavaram,
Yeah.
one after another, it says that 10 kilometers should be where this has not been marked or something like that. 56.8. I think Kaziranga is one where Kaziranga National Park is one. If you come to page 2022 10 SSC, 2022 10 SSC.
Yes.
544 minutes.
544.
56.8.
No, we'll go to 56.8.
Yes, 2210 SSC 544.
Just I mark it, just a minute.
Yes, please. There's the summary is at
56 para.
paragraph 6, 56.
56.
Yes.
56.1.
Yes.
Must have eco-sensitive zone of 1 kilometer measured from the demarcated boundary of such protected forest. 56.2.
Yes.
In the event, however, the ESZ is already prescribed as per law that goes beyond 1 kilometer buffer zone. a wider margin of ESZ shall prevail. If such wider buffer zone beyond 1 kilometer is proposed under any statutory instrument for a particular national park or wildlife sanctuary awaiting final decision is in this regard until such decision is taken, ESD covering the area beyond 1 kilometer as proposed shall be maintained. This is regarding proposed.
Correct.
If proposed is say 5 kilometer or 10 kilometer, it will prevail. Then 56.4, mining within the national parks and wildlife sanctuaries shall not be permitted.
This is below within.
Within. 56.8.
Yes.
In respect of sanctuaries or national parks, for which the proposal of a state or union territory has not been given, the 10-kilometer buffer zone as ESG as indicated in the order passed by this court on so and so and also contained in guidelines shall be implemented. Within that area, the entire set of restrictions concerning an ESG shall operate till a final decision in that regard is arrived at.
Yes.
So wherever no proposal, 10 kilometer. Then the subsequent order. Subsequent order.
This is below the
that is dated.
The first order is of Justice Lokur in anguish, as said by the subsequent case. It was said that it should be 10 kilometers. And now, if your lordships now take up,
April 26, 2023.
Yes. This judgment now is the ruling judgment and prevailing situation of law.
And there it was submitted.
Yes.
Apart from that, 104 national parks, 558 wildlife sanctuaries, total 662 national park wildlife sanctuary. Now, there it says the proposal for 121 national parks and wildlife sanctuaries in respect of which proposals have not yet been received. That includes Kaziranga perhaps?
No. That included Povitara.
Oh, okay. Kaziranga, what is the situation?
Kaziranga, they submitted proposals.
My lord, Kaziranga proposal is not submitted. Once it was taken back, my lord.
I think
no, my lord.
I'm telling you.
I have taken instructions from my officers, my lord.
Submitted, then certain things were pointed out. Therefore, they have taken over and they have not as yet refiled.
So there is just a minute.
My lord. This is what can I say? I am appearing on instructions.
That because in some other case, we have quoted from the proposal. So far, the distance is concerned. I don't remember which case it was.
My lord, there are some subsequent developments.
Okay,
My lord.
I'm not jumping.
No.
I'm just
Serious
team, I am trying to find out what is the latest position.
Yes.
Correct.
Thereafter,
Yes.
So may I suggest one thing, Milord?
Just a minute, sir.
Yes.
Then finally, in the second one,
My lords, I like to point out some small thing issue, my lords. Lordship, the order lordship is holding the 20, this order, my lord. Lordship will kindly come to the first paragraph of that order, my lord. Why it was filed.
Which one?
My lord, this order dated 2023 SCC Online SC 504, Justice Gauhati's order, my lords.
Yes.
The first paragraph, my lords. Why it was filed.
I have marked, sir. I have already marked.
Yes, my lord. For relaxation, my lord, of that.
I have read, sir.
Yes, my lord.
It was filed for direction or modification of 56.1 and 56.5. Now, here at the end, paragraph Paragraph 61.
May I just trouble your lordship with paragraph 60 also?
Yes.
Yes. Insofar as the restriction on mining is concerned, we are of the considered view that it has been the consistent view of this court that the mining activities within an area of 1 kilometer of the boundary of the protected areas will be hazardous for the wildlife. Though in the case of Goa Foundation, the said directions were issued in respect of the state of Goa, we find that such direction need to be issued on pan-India basis. 1 kilometer, therefore, my lord, has been now said by the Supreme Court to be the my lord, distance from the boundary of the sanctuary, which will be a buffer zone or which they have said is a soccer jabber. Now, if your lordship see, then 60. Insofar as the restriction on mining is concerned, we are of the considered view that it has been the consistent view of this court that the mining activities within an area of 1 kilometer of the boundary of the protected areas will be hazardous for the wildlife. Though in the case of Goa Foundation, the said directions were issued in respect of state of Goa, we find that such direction need to be issued on pan-India basis. We are therefore inclined to allow the present IA, the direction in 56(1) of the order dated 3rd June 22, that is Justice Bose's order, is modified and clarified that the directions contained therein would not be applicable to the ESJs, in respect of which a draft and final notification has been issued by MOF and CC, and in respect of the proposals which have been received by the ministry. We, however, direct that the central government that wide publicity should be given to the draft notification, which is required to be published under the provisions of clause A of sub-rule 3 of rule 5 of 86 rules. We further direct that the final notification to be published under clause D of sub-rule 3 of rule 5 of the 1986 rules shall not be given effect for a period of 30 days from the date of issuance thereof. It is further directed that any person who is aggrieved with such a final notification would be entitled to approach this court directly by filing an application in the present proceedings. We further clarify that the direction contained in paragraph 56(1) of the order dated 3rd June 22 would not be applicable where the national parks and sanctuaries are located on interstate borders and or share common boundaries. We also modified the direction contained in paragraph 56(4) of the order dated so and direct that mining within the national park and wildlife sanctuary and within an area of 1 kilometer from the boundary of such a national park and wildlife sanctuary shall not be permissible.
That is because of pan-India.
That is, earlier it was said we will do it in pan-India, and now this is the conclusion finally arrived at, that the distance of 1 kilometer from the boundary has to be kept compulsory. That is the direction.
Then 66.
Now, we also modified the direction contained in 56(5) of the order dated so and replaced the same as under. MOF and CC and all state union territories shall strictly follow the provisions of the guidelines dated 9/2/11, and so also the provisions contained in the ES zones pertaining to the respective protected areas with regard to prohibited activities regulated activities, and permissible activities. This is earlier discussed by the learned judges, that guidelines. We further directed while granting environmental and forest clearance for project activities in ESJ and other areas outside the protected areas, the Union of India as well as various state and union territory governments shall strictly follow the provisions contained in the Office Memorandum dated 17/5/22 issued by MOF.
So to my understanding,
Yes, ma'am.
subject to correction,
Yes.
the direction in paragraph 56.8 stands.
Of Bose's judgment?
The Moses judgment.
Okay, if
56.8.
eight,
If 56.8 stands, then it is 10 kilometers. And apparently DFO says beyond 10.
Let me assume for a moment that your lordship's interpretation is correct. So far as this case is concerned, it is irrelevant whether it is 1 kilometer or 10 kilometers, because it is the case of the DFO as well as the department.
No,
that this is
56
beyond 10 kilometers.
that is why I say 56.8. Subject to his reply, in respect of sanctuaries or national parks, for which the proposal of a state has not been given.
Correct.
The 10-kilometer buffer zone as ESG, as indicated in the order passed in Goa Foundation and also contained in the guidelines, shall be implemented. Within that area, entire set of restrictions concerned as eco-sensitive zones shall operate till a final decision in that regard is arrived at. If we say that no proposal, then also 10 kilometers. And your site is beyond 10 kilometers as per DFO's report.
Admittedly.
Now, there is the question to Mr. Gogoi. First, whether you controvert DFO's report.
That part I'm not going, my lord. Karbi Anglong,
okay,
Karbi Anglong has to
okay.
reply, my lord. That
No.
issue.
Ultimately, DFO, he is a transfer subject, but ultimately, finally, he is an officer of the state government.
My lords.
Whatever.
My lords.
Maybe borrowing authority, lending authority, those are different things. But ultimately, he is answerable to state government and Karbi Anglong Autonomous.
My lords.
So he says beyond 10.
My lord.
Periodic patta land beyond 10 kilometers. As on date, whether any proposal from the state government is regarding Kaziranga National Park is forwarded or as a draft within the state government, or it has gone to beyond state government.
My lord, initially a proposal was submitted. There were some flaws in it. That subsequent development, that proposal has been taken back. As of today, as we speak, my lord, there is no proposal. Issue is this, my lord, there are few corridors and few additions made to the Kaziranga. Earlier, my lord, a big chunk of Kolyabod area was inside that so-called that draft proposal. So it led to some issues. So the state government in its wisdom, my lords, that proposal was taken back. As of today, my lord, there is no proposal.
So it is now that, yes, Mr. Sutia.
Lordship, look, my lord, order passed by the Honorable Supreme Court in the, my lord, page 72, my lord. Now the CEC passed the order on the basis of that order, my lord. So I am pointing out, my lord, that order, my lord. 72, 12/4/2019 order.
72.
Page 72, my lord. My lord, that is only on the basis of this order, my lord, CEC interfered it, my lord. Consider the report dated through and through with respect of illegal mining in Kaziranga National Park, Assam.
Which part?
72, my lord, page 72. Then in the meanwhile, as certain matters are urgent, response be filed on so and so, my lord. You got it? In the meanwhile, ban forthwith all types of mining and related activities along the southern boundary of the KNP and in the entire catchment area. Now the CEC, my lord, in that particular catchment area, whether we have, my lord, catchment area, we have defined it, or this particular mining, my lord, that is in the catchment area or not. CEC made the queries on that, and the several communications were made, and thereafter CEC passed the order that no mining activities should be carried out in the catchment area. So, my lord, on the basis of the CEC report and the discussion with the CEC with the Chief Secretary at Gauhati also, certain direction was issued to the Karbi Anglong Autonomous Council by the Special Chief Secretary of the Government of Assam to ban forthwith all the mining activities in the Parku Pahar area. Accordingly, we have issued the ban order of, my lord, closure of the mining in that particular area. Then Lordship will look into it, my lord. I'll place the CEC order also, my lord.
This is page 72.
Page 72.
Is an order dated
My lord, 2019, my lord.
2019.
19. Thereafter, it was, we have filed the affidavit that we have complied it, that has been closed. But now again, it is reopened, my lord.
Then ultimately you submitted the report.
We have submitted a report. We have closed all the mining activities in that particular area, 33. We have submitted affidavit to the court.
That 33 petitioners.
No, not petitioner, my lord. All the 33 stone quarries which we have closed earlier, my lord. Now thereafter, my lord, after taking into that distance, my lord, we have allowed.
That has perplexed me. You catchment area, river area, whatever.
My lord.
On one hand, you are submitting before the Supreme Court.
My lord.
That we are doing it.
My lord.
Right.
We have done it, and that all 33
right,
structures have been closed, my lord.
And how this happened then? Page 28 and all thereafter?
No, page 72, my
No,
lord.
page 28 and all.
Page 28 is of 2021, my lord. Then, my lord.
No. Mr. Surya, that has perplexed me.
My lord.
In 2019, order came from the Supreme Court.
My lord.
Right.
My lord.
Catchment area and all.
This one.
You took time to file affidavit.
No,
and to suspend and all. And finally, the affidavit was submitted.
No, my lord, factually, my lord, when the Supreme Court passed the order in 2019, then we are asked to file the compliance report. Accordingly, we have filed the affidavit complying the order and enclosing all the 33 stone mine quarries which we have closed.
That is on 5/11/2024.
Not before that also we have filed, my lord.
Whatever, ultimately it has taken.
Same thing, my lord, same affidavit.
77,
my lord.
5/11/2024.
My lord.
And in the meanwhile, in the interregnum,
my lord.
In the intermediate period,
2019,
you started issuing settlement, environment clearance.
My lord.
Right.
My lord. That is
to
correct.
the petitioner, you got the mining plan approved.
My lord.
Then what is that called? That 2006 notification, environment clearance.
My lord.
Right. From
My lord.
Ministry of Environment, Forest, Climate Change.
My lord.
Right.
My lord.
So it appears that this is not part of the other exercise.
I am clarifying, my lord. As part of my lord, when the Supreme Court passed the order in 2019, my lord, when the CEC in 2019, my lord, submitted a report to the Supreme Court, my lord, then we have closed all the mining activities in that area, my lord. Then thereafter, my lord, the petitioner and other persons, my lord, they have submitted the application for shifting of the stone quarries to another place. Accordingly, my lord, environment clearance, mining plan was issued by the government of Assam, SIA, Central Government, Ministry of Environment, Climate Change, Government of India, issued the environment clearance. Thereafter, it was open, my lord. They are doing their, my lord, mining activities. Now, on the basis of the CEC's letter, my lord, subsequently, my lord, after closing all the matters before the Supreme Court, the CEC again taken up the matter on the basis of anonymous letter submitted to the CEC, my lord. Then it is in the report, my lord. Then the CEC asks certain queries to us, whether the National Wildlife Board permission is there or not, whether it is a catchment area is defined or not. Then we are taking the steps to allow whether it is a catchment area or not. We have entrusted a company to study it regarding the catchment area, my lord. Now, on the basis of, we have already, it is a not disputed fact that The environment clearance certificate, it was with the petitioner at that time, and their mining activities were going on. And after the Supreme Court's order closure, then it is again wrapped up on the basis of the letter wrote to the CEC. CEC issued the direction to the Chief Secretary, and our stand is that on the basis of the direction of the state government, we are closing it, my lord. Now, my lord, that is a factual part. Now, my lord, regarding today's, my lord, for lifting of the, my lord, mining.
Just a minute, just.
My lord.
Just a minute.
Earlier also, my lord, just I am pointing out, my lord.
Just a
Oh,
minute.
my lord.
My lords, my lords, can I seek indulgence can I leave for a moment while one under the court is giving personal attention? Hold it.
What is the authority and jurisdiction of the central empowered?
My lord, so I am pointing out, lordship, and look into the order passed by the, my lord, Supreme Court in that regard, my lord.
What would you?
Lordship, look into it.
Lord, CEC has now been made a
And
statutory
lordship,
body.
look into the regarding, my lord, that's interim order, my lord. And the coordinate base has also passed the order, my lord. Regarding the lifting of the stone materials from the, my lord, mining sites, my lord.
Mhm.
One point four, my lord. Any individual having any grievance against any steps taken by the government or any other authority in purported compliance with the order passed by the honorable court will be at liberty to move the committee for seeking suitable relief. The committee may dispose of such application in conformity with the orders passed by the honorable court. Any application which cannot be appropriately disposed of by the committee may be referred to this by it to this honorable court. So on that basis, my lord,
Right. That is why I'm trying to understand. Come to June 3, 2022.
my lord,
Right.
my lord,
Order, second paragraph.
my lord.
Various orders have been passed from time to time in this petition to ensure preservation of forest resources of this country to balance the economy.
My lord.
It is by an order dated 9/5/2022.
My
This one. A central empowered committee was directed to be formed primarily for monitoring implementation of this court's order
my lord,
and to place the incidence of non-compliance before us.
my lord.
It was to report to the Supreme Court. Supreme Court will pass the order.
My lord.
Right.
My lord.
Next, subsequently by notification dated 17/9/2022 by the Ministry of Environment and Forest in exercise of power under Section 3(3) of the Environment Protection Act, this committee was constituted under statutory provisions. CEC has been bringing to the notice to this court
My lord.
the steps taken for removal of encroachment, implementation of working plans, compensatory afforestation, plantation, and other conservation issues.
My lord.
It is bringing to the notice what is the authority and jurisdiction. Because 1.4 says you keep bringing to our notice.
My lord.
Right?
My lord.
And paragraph 2 also indicates that.
My lord.
Whether that statutory notification is empowered to stop, empowered the CEC
My
to
lord.
stop everything. Catchment area, broad catchment area,
My lord,
undefined,
my lord,
stop.
my lord. That will be answered by the Central Empowered Committee, my lord. That has been made.
Who
a
is not
party.
before this court?
My lord,
Who has been
my lord.
Who is not before the
I'm
court?
not representing my lord Central Empowered Committee, my lord.
So where is the notification, statutory notification?
Statutory notification is there, my lord. And it has been earlier placed.
Because Supreme Court says, please report to us.
My lord, my lord.
After the statutory notification, whether they have been empowered.
My lord. Under the, my lord, we have in our affidavit also, we have lordship will look.
Sometimes because I have to see, sometimes power goes to the head.
Supreme Court has said that about this CEC.
Right? Sometimes some indication is there. So power goes to the head. So that is why just I want to know.
24, 25.
And what about, what do you want to say?
My lord, regarding that, my lord, earlier, my lord, regarding lifting of the 2 days in a matter regarding a pass for interim order for relieving or like that, my lord. That coordinate base passed the order that they should approach the CEC, my lord.
One coordinate bench is allowing the other.
My lord, that coordinate bench, my lord, earlier which was allowed, that is in the report of the CEC in 2019, my lord. And on that basis, that the order, interim order passed by this honorable court, my lord, in 2018, my lord.
No. Here few orders
My lord.
are annexed. I don't know. That is why.
That is the order, my lord. That is the order that has been reflected, my lord.
Here few orders are annexed perhaps.
104.
And in 2019, my lord.
This, because to grasp the directions in T and Godavaran,
My lord.
it's very difficult for
My
me.
lord, my lord. Various orders.
One direction after another.
My lord.
For me at least.
Since 95.
Yes, and sitting
My lord.
at home or chamber, it is a different thing.
My lord.
But here, all these orders are passed in September 2025, say for example, page 107.
My lord.
And other coordinate bench is passing order in June 2025.
My lord.
Different orders.
My lord.
It looks like different orders. 107 for lifting.
For lifting, my lord, this in this particular case, when, my lord,
No.
that interim order was passed, my lord. My lord.
One coordinate bench
My lord.
is passing an order, interim order, allowing lifting.
Lifting, my lord.
Another coordinate bench
My
passing an interim order not to
My lord.
lift.
My lord.
See my position.
No.
My lord. My lord.
Has your lordship got an order where the coordinate bench has said that don't lift?
Ah,
Oh,
now he has placed.
Oh,
No,
I
we don't have that.
I don't know.
Ah. With regard to the petitioner, to allow them to take away the stone crusher.
This is stone crusher, my lord.
Oh, this is stone crusher.
Crusher. Stone crusher, my lord.
In different area, different thing. Everything different.
This is stone crusher.
Stone crusher, my lord.
Because we have
And
annexed.
out of that, my lord,
We are
particular,
hearing regarding lifting
My-
of.
my lord, that particular, my lord, that order, my lord, that I have placed it, my lord. That was earlier, we have banned it, my lord. And so they are filing the petition, repetition in the High Court, asking to leave the stone materials. In that particular contents, my lord, the coordinate bench rejected the prayer, my lord. And
In a different.
No. This is.
that is in his, my lord,
This is
when we
because-
have banned the order, that particular cleaned up stone quarries, stone crushers, my lord, in 2019, as per the order of the Supreme Court, then they filed a writ petition in the High Court that they should be allowed to remove the stone materials. That as the ban has already been imposed in that particular stone crushers, my lord, so the Honorable Court, my lord, rejected the prayer. And if they have anything, as it was in the, as per the Supreme Court's 2019 order, so they should approach the, my lord, CEC. That is the order, my lord.
You know, that is because your lordship has noted from that page 68. It is concerning illegal
Mining, my lord.
mining. We are not concerned with illegal mining. You have allowed us to
That is
mine.
what,
Yes, my lord.
because the stand, KAAC,
Now, our is that on the basis of the CEC's order and state government order, though they have the, my lord, valid mining permit at that time, we have suspended their mining operation. That is our
this is
stand.
illegal mining, you
My
have
lord,
stopped.
my lord.
Whether this mining is illegal,
My lord, now the Supreme CEC said that it is as a, you have not defined the catchment area, so you stop all the mining.
no,
activity.
where is
Where
their
is
power?
that power?
My lord.
Where is that power?
But that will be, my lord.
No, no,
CEC 's
no,
order.
no, you have to say.
No, no.
My
you
lord,
can't
that
take-
You also, because you are acting on CEC's direction.
This is not.
So lordship may look into, my lord, our affidavit then, my lord. What is our stand that, my lord?
No, no, Stan, I need the CEC's.
The CEC, my lord. CEC
Sometimes
report.
the power goes to the head.
No,
My
no.
So, my
is
lord,
why.
we
Your
have annexed the
lordship-
CEC's order, my lord.
Just
No,
one
no, no,
second.
power.
Your
Power.
lordship
Power,
may-
no. See, Mr.
Your lordship may just. Asen na
Mr.
copy.
Sutia,
My lord.
I have asked you to read paragraph 2.
My lord, I have read it, my lord.
Read.
I read
Where
it,
is the
my lord. I
notification?
understand it, my lord.
Where is the notification?
Considering CEC, my lord.
Yes.
It is the,
Please.
yes, my lord.
CEC was made
My lord.
permanent by.
I have understood.
Hmm.
To that extent, I have understood.
Notification, gazette notification. Gazette notification is there, my lord. In the earlier we have also. And
what-
we have mentioned it in our affidavit, my lord. What is the contents of that notification?
I'll see
No,
firstly.
just 1 second. My lord is saying something different, and there is a reported judgment of the Supreme Court concerning the CEC.
Yes.
That is, my lord, your lordship will find this is 2024, one
This is a site,
SCR,
we can pitch.
SCR 11,
What is the citation?
2024,
One SCR.
one SCR 1194. I'm just sending over. my lord.
No, we can take out.
Sorry, Lordship, I did not put the extra.
In any case, we are of the view that once an order is passed by this court, it is not appropriate for a committee which was constituted under the very orders of this court to give a report which in effect questions the correctness or otherwise of the orders passed by this.
Because para 56.8 is clear. That the entire set of restrictions concerning an ESG shall operate till a final decision in that regard is arrived at of the June 2022 order, which means 10 means 10. Now, who comes with catchment area? Somebody else.
Mailed it, my lord. There's a notification of 2023 by central government has notified the CEC.
Yes, please.
Yeah, that we have given.
That is what I want to have a look.
You have given that. We have given it, no?
Is it part of?
No, no, we have just handed over. Court cut dila. This is 5th of
This was
September.
first formation by the court's order.
My lord.
Yes.
My lord.
Subsequently gazetted.
Gazetted, my lord.
5th September 2023.
5th September 23, correct.
November 2022.
5th September to 2023. Because
No, para 2 of June 3 order. Mr. Sutia, do you have this June 3, 2022 order?
Para 2, my lord. That is, my lord.
17
That
September 2022,
My lord.
Ministry in exercise of power,
my lord.
committee has been constituted under statutory provision.
My lord.
And next line is also important. CEC has been bringing.
My lord. She has been bringing to the notice of this court the steps taken for removal of enforcement, implementation of working plans, compensatory afforestation, plantation and other conservation issues. Then, my lord, relevant is the, my lord, lordship has already read 56.1 and 56.8, as lordship has already. 56.1 and 56.8, my lord. That is the 10 kilometer when the boundary is not defined, my lord. Or eco-sensitive zone has not been notified, my lord.
Two to 11 to put us in 9 to 11 of guidelines.
Oh.
That's easy to accept with.
সেইটো নতুন এটা judgment আছে।
গোটেইখিনি
আৰু তাত গোটেই হেৰিখিনি দিবলৈ দিছে সেইটো।
Well,
subsequent there was another judgment of the Supreme Court regarding CEC, my lord. That
Before judgment, have a look at the notification.
notification is there, but I have looked into it, my lord, and we have stated in our affidavit also.
No, look at the
My lord,
notification.
my lord, I have already looked into it, my lord. So we have,
Where is the power? Where is the power?
my lord,
Which section?
my lord, Supreme Court, my lord,
September 2023,
my lord.
right? This is the notification.
Notification, my lord.
Committee shall exercise following powers and perform the following functions.
My lord.
Powers and functions conferred upon the committee
My lord.
by the Honorable Supreme Court of India.
My lord.
Right. One, to monitor the implementation of the Supreme Court's orders.
My lord.
Monitor.
Monitor.
First, I think it is clear. B, to deal with any application made to it by any aggrieved person.
My lord.
Right?
My lord.
One can complain.
My lord.
Next,
My lord.
and wherever necessary,
My lord.
comma, to make a report to the central government in that matter.
My lord.
Only reporting.
My lord. We have stated
Not
our view. My lord.
order,
My lord.
direction,
My lord.
central government,
My lord.
not to KAC or state government,
My lord.
I think. C, for the purposes of effective discharge of powers conferred upon the committee under this order, the committee can call for any document from any person,
My lord.
undertake site inspection, seek assistance of any person, co-opt one or more member as special invitee,
My lord.
co-opt the secretary of the state government dealing with the subject. Next, to suggest or recommend measures generally. Then to examine and advise or recommend on any issue referred to the committee by the central government from time to time.
My lord.
So where is the power to stop catchment area?
My lord. They are probably, my lord, they are exercising the power A, my lord.
A,
To monitor the implementation of Supreme Court's order. So,
where is the catchment area Supreme Court?
my lord, that is 19/4/2019 order. Catchment area is there, what catchment area.
That is
So,
with regard to illegal mining. That is
my
the
lord,
difference. You
so
are not making.
so the central empire, if your lordship look into the our affidavit, what is the orders and CEC, my lord? Annex 6, page 147.
Again, let us look at 68.
No, page 72, my lord, 72. That was the order, my lord. Now they are monitoring this particular order. Monitoring this particular order. In exercise of their power, they are issuing, my lord.
68 is the first order and that is subsequently.
68, right, 68. Just a
72 is the final order.
Consider the report with regard to illegal mining.
The whole thing was with regard to illegal mining. And that is the difference here.
My lords, 1 minute, yes,
No,
you have to
that-
go somewhere.
No, no, my lord, since lordship is looking at that, what I found out after that notification, my lord, there's another judgment which somehow it enhanced the power of the.
Let us, we'll look at, just.
So, my lord, Supreme Court's order, page 72, last line, my lord. In view of the aforesaid, we order that all kind of mining and related activities along with the aforesaid Kaziranga National Park area and in the entire catchment area. So that is the word used by the Supreme Court. Of river, streams and rivulets originating in Karbi Anglong hill ranges. So there is a vast, they may be at a vast area like that we also, my lord. So that catchment area, CEC only now asking that these minings are whether it is in the catchment area or not, my lord. On that basis, my lord, CEC passed the order.
But that question are not to
Come to page 44.
40?
That is.
44 again.
Okay, exactly.
Condition number 1,
My lord. My lord.
your officer.
My lord. My lord. Yes, my lord.
Beyond 10.
My lord.
And no river streams
My lord.
or rivulets
My lord.
in a vicinity of the proposed mining area,
My lord.
which flows into Kaziranga National Park.
My lord. My lord. Yes, my lord. I cannot deny it, my lord. At that time, it was issued. But what is our stand now is that, my lord, at that time, Kaziranga National Park file, KML file, was not with us. That was forwarded to us in the year 2024. So without looking into, my lord, that's what is our stand, my lord. I'm only stating that one, my
Stand is
lord.
one.
My lord.
Stand can be taken without any basis.
My lord. But that is the
And
basis.
stand can be taken on the basis of materials also.
My lord.
No,
My lord, yes,
this
it is
a
correct.
statement by an officer.
My lord,
of the
at that
rank of
time,
DFO.
my lord,
Right.
my lord, yes, it is correct, my lord. DFO issued that certificate and on that basis,
Ultimately, that proceeding almost culminated because satisfied by your action.
my lord, the Supreme Court closed it.
Supreme Court closed it.
Now again, it is, my lord, CEC passed the order that it is.
That is I'm not finding out where is the order, power to pass such order.
My lord,
This
my lord,
notification does not say so.
my lord. Only that they have the power to monitor the implementation of Supreme Court's order.
That
So,
56.8.
my lord, 56.8, my lord, that it is 10 kilometer. Now, my lord, when we have, not in this particular case, my lord, in certain other cases, about 10 cases are pending.
We are not into it.
My lord.
We are not concerned.
So, my lord, in this particular case, my submission is that whether it is at present, my lord, after receiving the KML filed from the director of Kaziranga National Park, whether it is within 10 kilometer or beyond 10 kilometer, I have no instruction at this moment, my lord. That is my submission for today, my lord.
We go by your record.
My lord. Yeah, as on date, my lord, at that time, my lord.
Yes, which order empowered? My lord. Which order empowered?
The CEC.
CEC
CEC is.
to stop, to pass restraint order.
No,
You said.
that I'll think over, my lord. I'll have to look
Think
into.
over is not.
I'll look into, otherwise, my lord, CEC, there's another judgment of 24. Somehow it has been enhanced, power not to that, it should have a secretariat, it can make site visits, it can submit reports.
Just for your information, 2024 Supreme Court commented. Right. Supreme Court commented.
My lord.
I'm not commenting.
Impact committee.
That it is not appropriate for a committee
Impact
which was
committee.
constituted under very orders
Environment.
of this court to give a report which in effect questions the correctness or otherwise of the orders passed by this court.
My lord.
Right? 2024.
24.
This CEC same CEC. Right? So, whereby it has been empowered. Supreme Court has not empowered. Because after notification in 2023, giving it a statutory color, there it is monitoring and all. then somehow, I have not read it. It stepped beyond it. Then Supreme Court commented in 2024 in that manner.
My lords.
And here Mr. Sutia is saying, TEC had directed. See, as part of notification, CEC can only give its monitoring report to the Supreme Court or any recommendation to the central government.
My lords.
Right. Anything else? Because these are
But I
big
cannot.
big sensitive
My lord.
issue. That is why
Yes.
trading with.
I am confining myself to the 10 kilometers, 10 miles, but otherwise,
Let me assume, my lord, for the purpose of argument, not admitting that 10 kilometers is decided by Supreme Court, which is really not done because Supreme Court itself has said in that Gauhati's judgment that Supreme Court has never stated that 10 kilometers should be the buffer zone. Therefore, let me assume, Baro, for the sake of argument, that 10 kilometers.
Yes, we assume because there is no proposal as on date.
And
so 10 kilometers, so that is a, otherwise it looks like maximum. It looks like maximum
because my lords,
one,
yes,
and it looks like maximum as on date.
my lords.
If Mr. Google proposes 20 kilometers or 30 kilometers, that is a different issue.
different.
And 56.8 remains untouched as on today, my lords. That is, I'll confine myself to that only. Otherwise, when the CEC's actions, I cannot defend because I don't have any kind of authority from them. And all I can assist this court, and I have assisted that notification I have provided, judgments I have provided.
And you said catchment area you have done.
Lordship will look into it, my lord. We have closed it as per the direction of Special Chief Secretary Forest to the Government of Assam. Lordship will look into our affidavit, my lord.
So it will go by stages.
Just Lordship will look into our affidavit, my lord. What is the direction, my lord?
No, let us learn at least for me, at least for
Everyone-
all times to come.
Lordship will look into page 142.
Otherwise, I have not dealt with Godavaram.
My lord, Lordship will look into page
Because
142.
otherwise, Mr. Google will show Godavaram on day-to-day basis and I will be perplexed. So
Page
that
one-
is why I am trying to understand.
My lord,
We are also disturbed by Godavarman, my lord. There are 2 Supreme Court volumes of Godavarman only.
Correct.
my lord, Lordship will look page 142.
Mr. Gusar, please see.
Page 142. Minutes of the meeting dated 27/12/2004 on application number so and so of the Central Empire
144.
Committee.
144.
My lord, 142. Minutes of the meeting dated so and so on application number so and so, Central Empowered Committee, New Delhi, in the office number so and so, Special Secretary to the Government of Assam, so and so. At the outset, Special Secretary to the Government of Assam, well, so and so. The matter on the application number so and so of the Central Empowered Committee, New Delhi, regarding the alleged mining activities carried out in the Parku Pahar range under Karbi Anglong Autonomous Council vis-a-vis the order passed by the Honorable Supreme Court of India relating to the ban on mining activities around Kazino Bhai order dated 12/4/2019. That is the order, page 72. Was discussed at length by the members present. After a threadbare discussion, the following decision has been taken as indicated below. The Divisional Forest Officer Karbi Anglong East Division will issue a ban on all mining activities in Dolabara Range, Parku Pahar area from south of Bagori to Borjuri waterfall areas with immediate effect. Next, the Divisional Forest Officer Karbi Anglong East Division will submit a comprehensive report on the alleged mining activities presently undertaking in the above areas within 3/1/2024. It was decided that the so and so CSD Karbi Anglong Autonomous Council Chief Conservator will so and so and furnish its report to the Government of Assam. The meeting, that is the order passed by the Special Secretary to the Government of Assam. Yeah, my lord, next 143. There was a direction on the basis of the application submitted to the CEC, my lord. So the suspension and ban on mining activities of the petitioner in pursuance to this order, my lord.
Come to 144.
My lord. That is the, my lord.
This is the report.
My lord, it is 56.8, my lord.
Huh?
That is a 3622 judgment that has been quoted by the CC.
But he referred to 44B.
44B, my, there is a numbering is the different, as it is from the Supreme Court judgment, it is from the SCC volume. So this is the same thing, my lord.
SCC volume is, I am with.
Yes, 56, my lord.
What happened? No, I'm trying to find out.
Yes.
This one, this is 44.
The same language, my lord. The 56.5, my lord.
The website opening, right?
No, not 56.5.
No.
56.2, 56.2. Same, my lord, 56.2. In the event, however, the eco-sensitive zone is already prescribed as per law that goes beyond 1 kilometer buffer zone, the wider margin of as eco-sensitive zone shall prevail. That has been quoted, my lord. CC.
Yes, that is,
It is on the,
Just CC later.
it is on the presumption that a draft ESD notification has been issued.
At that time, it was issued, my lord.
Huh?
At that time, it was issued. Subsequently, it was withdrawn, my lord. Notification, my
Yes,
lord.
Mr. Gauhati,
Yes, my lord. Yes,
correct.
my lord. Yes,
Yes, Kaziranga, I have stated, my lord, earlier.
My
that
lord.
the draft was
I understand.
forwarded, then it was recalled, my lord.
Earlier, my lord, that draft notification was sent to the ministry, my lord, Environment and Climate Exchange.
That was
And that was subsequently draft notification was sent. Then it was, my lord, when the Koliabor issues are there, 7 issues, then it was withdrawn, my lord.
So as on that, no.
No, as on that, no.
So 56.8, not
56.8.
56.2,
Oh, my lord, 56.8, my lord.
not 56.2.
56.8.
56.8, my lord. Oh,
And your river catchment,
my lord. Then,
that ends in, that ended after submission of your satisfactory report.
at that time, my lord.
At
My
that
lord,
time.
then Supreme Court closed it on the basis of our affidavit, my lord.
Yes.
Yes. Now, my lord,
So-
when the CEC, my lord, asked the catchment area,
So
we have
this has
engaged,
nothing to do with catchment.
my lord.
This report is nothing to do with catchment.
My lord,
If I am correct.
my lord, my lord. Initially, that is the,
It
my
is
lord,
simply with 56.2,
my lord, at that time,
which
56.
we are, the present situation is not existing.
My lord, then, my lord, another report, my lord, 147. Again, my lord. That was on 20th March 2025. The next one is 35 2025.
What they are writing, Supreme Court Direction 12 for 2019.
That order I have page 72, my lord.
But that has culminated in.
I culminate to my lord, on our affidavit. That has been closed. But the Supreme Court closed the matter, but the
My presumption is
so the
gathering force.
so lordship may look into page 156. What is the conclusion of the CEC? So that is the Supreme Court's order has been quoted, my lord, that two particular paragraph. Then the direction. The Chief Secretary, Government of Assam shall ensure that these orders of the Honorable Supreme Court are complied with letter and spirit. The Honorable High Court of Gauhati shall be apprised of this order of the Supreme Court by the KAC as well as the Forest Department by filing a suitable petition requesting the Honorable Court to review its order dated so and so in view of the direction of the Honorable Supreme Court of India. The Director of General Police of Assam and the concerned superintendent of police shall ensure that no illegal mining takes place in the aforesaid area and no transportation of illegal mined materials takes place from Karbi Anglong Hills. The Karbi Anglong Autonomous Council shall complete and submit a comprehensive watershed drainage analysis. So that is the direction to us, my lord. Report to the CEC by October 2025. Clearly identifying all watershed areas draining into Kaziranga National Park.
They have to report to the central government or to the Supreme Court, I think.
But the direction was to the, my lord, we have to, now, my lord, periodical report is required to be submitted to the CEC by us.
Supreme Court directed.
My lord, that is a CEC direction.
The CC reports to.
They said that,
Now, my lord, paragraph 6, the Karbi Anglong Autonomous Council shall submit quarterly status report to the CEC through the Chief Secretary to the Government of Assam, detailing the action taken or reported violation cited in the earlier factual report. Fine. So,
Mr. Gugoi, other than this notification, any other notification of
CC.
CC?
No,
That is 5/9/2023.
no. Only after that, the judgment came, January 31, headed by Justice Gauhati, and it provided them, the CEC was given some state, their perks were determined, and some additional powers to form guidelines for own management that was given, nothing else.
So this is the only one.
This judgment, Lordship, I have already placed 2024 judgment.
Digital.
Yeah, that 31st January.
CEC was given
Para 11.
secretariat.
Para 11.
Para 11.
11 and 32. I think.
Para 11 and 32. Para 32.
Petition 16.
6/16.
22 to some, 22. Wait, move to there.
6/16.
One comment is important. Supreme Court comment. A committee which is constituted under the orders of this court cannot consider itself to be an appellate authority in regard to the orders passed by this court.
My lord, I visited the office of the Central Empowered Committee, my lord.
And says Supreme Court itself says, I have gave birth to the baby. Now baby has grown bigger than me, and it becomes the appellate authority.
Constitution There are 32.
Then one more. We are of the view that once an order is passed by this court, it is not appropriate for a committee which was constituted under the very orders of this court to give a report which in effect questions the correctness or otherwise of the orders passed by this court. My intuition is gathering force.
They have questioned, we have got that order.
Baby has grown bigger than the father.
Yes.
I visited the office, my lord, along with the additional chief secretary, PCCF, additional PCCF, superintendent of police. Everybody was present in the meeting, my lord. And
Everybody heard.
And my lord,
Everybody
and
abided
the
by.
chairman of CIA also, my lord. Everybody was present. CC passed certain orders, my lord. At that.
There are 32
There are
also.
32 of them.
32 of the judgment.
32.
32.
Now, my lord, as the CEC passed the order, and my lord, the validity of the environment clearance, it is expired, my lord. Whether at this moment, my lord.
No, validity or invalidity is asking for lifting of the material.
My lord.
let us
My lord.
confine to that.
My lord, my lord, my lord.
We are not
My lord, as on today.
lifting the ban or whatever.
My lord,
Right?
my lord, my lord, as on today, as there is no valid EC, my lord, so whether the lifting of the already extracted stone can be allowed or not. That is the point Lordship may decided and passed the order. my lord.
No, what is your submission to that?
My lord, our submission is that CEC's order bind us, my lord. The Karbi Anglong Autonomous Council shall strictly ensure that no violation of environmental norms or mining regulation occur as expressly assured by the Forest Department during the hearing before CEC. So as on date,
And what about the coordinate bench order?
my lord, that order, my lord, that order was placed by me before the CEC, my lord. The court passed the order, contempt petition is filed, so we are bound to comply with the order passed by the High Court,
No,
my lord.
and-
It is a judicial order.
And this court,
Judicial
for
order.
judicial propriety and
my lord,
consistency,
the-
also has to follow the,
my lord,
unless it is reversed.
Executive order cannot bypass the judicial order, my lord. So when the judicial order pass, we are bound to comply it, my lord. So that was the submission made to the, my lord, CEC also. And now, my lord, as on date, as there is no, my lord, mining, EC is there, so whether it can be permitted to leave the extracted stone materials or not, or whether it can be treated as illegal transportation. So that is only the point, and Lordship may pass the appropriate order, my lord.
Okay, I'll pass the order tomorrow. We'll leave the case.
Just one citation. but
Oh, one more.
My lords, that order they were relying on, my lords, the interim order. Interim order doesn't act as a precedent, my lords.
Which
Just for my convenience.
No, I am not saying about a precedent.
No,
but
no, no.
It is by a coordinator.
I am just submitting, my lords.
And my lord, so far as this is concerned, this environmental clearance is on 17/6/23. And our period is 2 years, so it will be in 25 June at the most, if we go by their submission. But our
Your
suspension is in January.
issue was which date?
My lord, 17/6/23 at page
17.
36A.
Is 42 already.
17/6.
Now, the suspension order at page 52 is at January 25. During the currency of the EC.
So the lifted material prior to that.
Prior to that.
17/6/2023, my lord, EC, my lord, it is valid for 2 years, that is page 42.
And suspension order January.
January 2025, my lord.
Whatever was extracted prior to that.
January
there was lifting of
2025,
that.
my lord. Prior to January 2025.
Before that, therefore, we are asking, you have taken our
You'll be
money.
there, so the dates are,
My lord, my lord,
I'll get confused with the dates.
my lord,
Right?
my lord.
Tomorrow.
My-
Had Mr. P.K. Goswami, and senior counsel, presented by Mr. B.P. Bora, Mr. D. Louis, Leonard Standing Counsel, Forest Department, and Mr. J. Shukia, Leonard Standing Counsel, KAC, for the respondents, but it is the case tomorrow. Okay, I have learned a lot.
My concern is only Kaziranga, my lords, that 10 kilometers. Kaziranga. Sensitive.
10 kilometers, your officer has said.
We go by 56.8 only.
Yes, my lords.
And your officers only. And some observation as regards baby growing.
Milord, may I just
All.
one thing, Milord, page 36. Environmental clearance, and at page 37. Everything was examined. Don't say that it is all illegal mining.
Anyway, it will be an interim order.
Yes, yes, interim.
Subject to.
And they have taken the money.
Subject to application for vacating or subject to read.
Yes, yes, that is all.
Forum will not be closed.
Correct. Absolutely.
Right, it can be tested.
My lords.
No, what I was trying to show at page 37, just have a look, 1 minute. It starts with us.
37, yes.
The proposed 37, the proposal was examined and processed in accordance with EIA notification 2006, which your lordships find in Justice Gauhati's judgment.
36. 7.
37.
EI. EI, obviously, EI.
Yes.
2006.
That is the notification of 2006 and its amendment thereof. The state level expert appraisal committee examined the documents of the proposal for extraction of stone at the meeting on 25-23. Accordingly, the application was discussed and thoroughly scrutinized by the SEAC and found that the project falls under 1A and considered as B2 category of notification of
EI.
2006 and subsequent amendments. The committee recommends the project to the SCIAA Assam for issuance of environmental clearance. Therefore, my lord, in Gauhati, Justice Gauhati's judgment, your lordship will find that this notification of 2006 has categorized prohibition, prohibited items, regulated items, and another item. And they have found that this is permissible under that notification, and therefore they recommended that the environmental clearance should be given. So it will be very wrong on the part of the government or the council to say that this was an illegal act. There is nothing illegal about it.
Okay. That will be only tentative view, whatever.
Yes, yes. That is, my lord, they have taken the money, the goods are lying there, people are in need, and prices are going because people are not allowing. And that will not, the public interest will not be.
Item 53.
I'll do that needful, Sahala. I'll put it Friday. This Friday. I'll do the needful. I have heard already.
Yes, ma'am. Can it be on Monday, my lord? Friday.
I will note down if it is possible. Otherwise, I have heard it is for me.
Yes, my lord.
In your absence also, it can be passed.
Yes, my lord.
Right? It can be disposed of.
Yes, my lord.
I have recorded your submission.
Yes, my lord.
Even if it is supposed held to be bad,
Yes.
then fresh.
Yes, my lord. Liberty. Yes, my
granted.
lord.
And it is his that prior opportunity was not there, so
Yes, my lord.
the department notice should go.
Yes, my lord.
Okay. Sahavala, Senior Counsel, voted by Mr. M. Sahavala, petitioner, DP Bora, Litigation President, is the case again for consideration, final consideration on, is the case on so and so for final consideration. I'll try to do it.
Yes, my lord.
By Friday.
For orders, item 37.
Please, your lordship. My lord, in this petition, as per last order.
You filed your procedural?
Yes, my lord.
Heard Mr. M.J. Kwari, Learned Counsel for the petitioner, Mr. S. Dr. Learned Standing Counsel, Panchayat and Rural Development Department for the response number 1 and 2. And who is response number 3?
Response 3, my friend appeared already. Roy had appeared. And he is transferred now.
He is private respondent.
This
is a contempt. Okay, contempt.
Deputy District Commissioner, my lord, 3. In his place, respondent number 4.
1 minute. Issue notice to the newly implemented respondent number party, respondent number 4. Post up. No notice is made returnable on so and so. Counsel for a petition shall take steps for service of notice by speed post within 2 working days from now.
My lord, in addition, may we take a dusty, my lord, in addition?
No, contempt.
My lord, I have filed one affidavit, my lord. Copy has been served on 4/2/2026. I have checked, my lord, that was not in the record. Actually, because of some technical issues, my lord, that was not registered. But today we have cleared, my lord. That may be.
Okay, Mr. Doctor. Standing counsel, no, Learned Counsel for Mr. Doctor has submitted that and Additional affidavit.
Rejoinder affidavit.
A rejoinder affidavit has been filed on behalf of the
Respondent
respondent
number
one and two.
Two.
Two. Full stop. Initially, the affidavit was with defects, but the defects have been rectified. Have since been rectified. Full stop. Let the to trace out the said additional affidavit to tag it with the case of fraud.
Highly obliged, ma'am.
22nd April.
Right.
Obliged.
Right. Highly obliged, ma'am.
Item 38. So can we pay this last order, madam? 6/3/2025.
How I contempt order will use.
Lordship, the repeal was listed last, Lordship, yesterday, Lordship. So it could not be concluded due to paucity of time, Lordship. It is further fixed on 17, Lordship. 17 March. Possibly on that day, it will be finally adjudicated. The
Adjudicate on delay or adjudicate on merit?
Lordship, honorable courts, considering both the Lordship delay petition as well as the merit of the case, Lordship. So either it will be dismissed, Lordship, or it will be considered on merit, Lordship.
We proceed, there is no stay order.
There is no stay order, but Lordship,
We give you a last chance to comply or either to comply with the order or to place
Lordship,
a order of stay,
Lordship,
either of the two.
Lordship, after 17 more, Lordship, it may be.
Mark করা তো নাই নাকি? Mark করা তো নেই। এইটো mark কৰিছো নাই। Mark কৰা নাই, পঢ়িব লাগিব। এইটো আছে নেকি? এইটো আছে নেকি?
Operative part of the order is paced by 25.
On 6/3/2000, heard Mr. N.N.B. Chaudhary, learned counsel for the petition, and Ms. R. Devi, learned counsel for the respondent number 173. Full stop. Para. On 6/3/2023, the following order was passed. Para 2 pa 10 lo likhi do. Para the contempt petition is preferred. Alleging non-compliance of the direction made in a judgment dated 14/3/2024. No time period was granted.
Yes. My lord.
No time period was
Yes, madam.
indicated in the
That
judgment.
doesn't, that forever, my lord. Not complied order.
In a writ petition WPC number
Now 2024.
497/2023. Post. The writ petition was preferred by the present contempt petitioner as the writ petitioner agreed by denial of
I feel it.
the benefit under price variation clause within bracket PVC in respect of a contract work for construction of 12 numbers of double-story type 2 quarters at Bongaigaon and Borpeta Road, etc. He had executed for the respondent NF Railway Authorities. Full stop. The tender value of the contract work was rupees 5,61,10,418.74, is 13. And the tender value was rupees 4,53,21,255.
Contract value.
It was contract value.
Contract value.
Oh, first was tender value,
Tender value.
second was contract. The court, after hearing the parties, had recorded a finding that the petitioner would be entitled to the benefit of PVC clause and a direction and the competent authority in the respondent NF Railway Authorities, more particularly, the respondent number 3 and 4 therein were directed to determine the claim of the petitioner as per law and in terms of the contract, taking note of the determination made. Full stop. Para Mr. Chaudhary, learned counsel for the petitioner, has submitted that no time period was mentioned for completing the exercise. No, in the no time period was mentioned in the judgment dated 14/3/2024 to complete the exercise. Full stop. The present contempt petition was preferred after expiry of
That's my last 6 month, man.
6 months on 12/9/2024. Full stop. He has submitted that a period of 6 months was a reasonable period for the respondent authorities to complete the exercise. Full stop. As despite elapse of 6 months, the exercise was not carried out by the respondent authorities. The petitioner was compelled to prefer the present contempt petition. Full stop. On perusal of the affidavit, how many affidavits?
Only one affidavit has
On perusal of the affidavit filed by the respondent number
two.
2. This court finds that there is no statement to the effect that the reason for not completing the exercise was unintentional. On a query to Ms. Devi, it has been apprised that the period of delay which have occurred in preferring the preferring the appeal, writ appeal, has not yet been condoned. And the writ appeal, the writ appeal which has been preferred, has not reached the position to be examined on merits.
Delay was also not condoned.
Right.
Yes.
No, but is yet to be condoned. Is yet to be condoned. Full stop. Para. In such obtaining fact situation, comma, it transpires that as the delay is not yet delay occurred in preferring the writ appeal has not yet been condoned, comma, the writ appeal has not reached the position for its consideration on merits. First. The law is settled that a party once becomes a party once he is aware of an order of a constitutional court and does not act in a manner which is suggestive of initiation of any steps for compliance of the direction made in an order, then any such conduct which is again in breach of the order is clearly suggestive of an act which comes within the purview of contempt jurisdiction. Full stop. It is তাৰ আগত লিখিব লাইনটো আগত লিখিব নালাগে 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 From the statement made in the affidavit of opposition of the respondent number 2, it appears that comma, filed on 3/6/2025. In the affidavit information. Though he made mention of no, from the stand taken by the respondent number 2 in the affidavit in opposition, it appears that the intention of the respondent number 2 is to proceed for implementation of the order dated so and so. Would be conditional on the outcome of the writ appeal. Full stop. It is there is no bar in preferring an appeal against preferring an intercourt appeal against the order dated so and so. But it is always the duty of the alias contender to first comply with the order. So stop. Depending on the outcome in the intra-court appeal, further steps stroke adjustments could have possibly be taken. So stop. But it is not open to the alias contender to not comply with an order of this court on the mere filing of an intra-court appeal, which has been found with delay of
243 days.
245 days,
43 Lordship.
243 days.
243 days.
Full stop.
After filing of the contempt petition.
That too, after filing of the contempt petition.
Appearing, no?
It is also not the case of any of the respondents. They do not, that they are not in a position to comply with the order dated so and so. And on the ground that the direction was beyond their competence. Full stop.
Lordship, there is a judgment of the Honorable Supreme Court Lordship regarding proceeding with the contempt proceeding Lordship during the pendency of the appeal, even if there is no stay order Lordship. That's it.
But in the above obtaining fact situation, a last opportunity is granted to the respondents.
It's a quoted
Either to comply with the order dated so and so. Or to place an order of stay. Or to produce a stay order. Full stop. The decisions in special leave to appeal C number 2713/2025. Within bracket Mohendra Dev versus the order dated 3/2/2025. Passed in special leave to appeal C number 2713/2025 within bracket Mohendra Dev versus Radheshyam Pandey. And the judgment in Contempt petition civil number 5/2026 within bracket Israr Ahmed Khan versus Amarnath Prasad and other decided on 24/2/2026 are placed before this court and the same are perused. Stay order decided. Stay order. So no affidavit by respond number 2, even if respond number 3, respond number 1. So that is your 2025 judgment. Detailed judgment in 2026, February. Pretext of filing appeal with delay, all these have been considered. By the next list. Your case is on 17th.
Lordship, 17, it is fixed on 17, Lordship.
23.
Lordship,
23.
23, Lordship.
23.
Lordship, it may be taken up on the first week of April.
Show it to the court, my order, show it to the appellate court. Get the stay.
I should not mention what is the view of the court. She know very well.
Get the stay.
Yes, Lordship.
Show my order and get the stay from the judgments.
Lordship.
It is deliberate disobedience.
Lordship.
Next.
Obliged, Lordship.
39 to 42.
Can you produce the last order?
Order because this one.
6/3/2026.
Yes, sir.
Received some instructions, my lord, of the same nature, my lord. I can not in a position, my lord, to effectively put any adjectives, my lord. But lordship may be pleased to peruse.
For contemplation, preparation came up for consideration. Yes, an instruction.
Rolling data to one about us. Rolling data from definitions.
So, one more committee has been constituted on 4/9/2025.
Yes. Now that committee has been constituted now since these contempt petitions were looming large. So therefore, this honorable court from time to time had passed the orders that it has to be complied with. There is no other way. Now that committee has been constituted and the report from the committee.
Now, what is the function of the other two committees then? I have quoted paragraph 5 in your affidavit says.
Yes.
And after 2 inquiry reports were received.
Yes, this was.
Then thereafter, again one committee.
Yes.
Again finding.
Yes. Again.
Then thereafter, petitions were disposed of.
Yes. Petitions were.
Right. 2 inquiry reports.
This committee, individual.
2 inquiry reports. Then one committee constituted, examined the 2 reports, gave his findings. Thereafter, petitions were disposed of. Court direction was made. Then again, one more committee.
Yes. Now, my lord,
either to comply or to file a writ appeal.
Lordship is absolutely correct. My lord. There is no way of.
This is my very limited understanding.
Lordship is correct. I have to lift my hands, my lord.
So,
now,
the coordinate bench has observed on 7/1/2026.
Yes.
That given impression that the department is sitting over the orders of this court.
Absolutely, Lordship is absolutely correct, my lord.
I did not.
No, my lord, we go down. But the distinguishing factor since.
If this is the position of the court as well as the standing counsels and the counsels representing the client.
Now, Lordship will kindly appreciate one aspect of the matter since Lordship has just now made a point.
Everybody is undermining the.
No, my lord, it is not that, my lord. Lordship will kindly see, my lord, it is not a case, my lord, that where we have not taken any step whatsoever for complying with the court's order. We have taken steps. Now, my lord,
it is just like Awad Assam Express.
No, my lord, Lordship will,
right.
Lordship will kindly.
Its destination is to be reached within 42 hours, but it reaches at 90 hours, 4 days, 5 days. I had the experience of boarding over Assam.
Correct.
Right. So ultimately it will reach the destination 2-3 years.
No,
5 years. Already 10 years.
Already 10 years. Now, my lord, so far as my lord, the earlier committee is concerned, which Lordship has just now posed a pointed query, my lord. The earlier committee had taken a overall view of the matter, my lord, no, my lord, the present committee, Lordship will kindly appreciate, the present committee is now examining the individual claims, my lord, of these 4 writ petitioners, my lord, culminating into, my lord, 4 contempt petitions. And Lordship, on the last order, my lord has clearly depicted, my lord, at paragraph 2, what is the quantum of amount involved, my lord.
Okay, paragraph 2 of your latest instruction.
Yes, my lord. Now the financial.
Okay, giving you chance like the earlier one.
My lord, it is very embarrassing on my part, my lord, to make any further submission, my lord. That much I can fairly submit before this honorable court. I am also an officer of the court, my lord.
But in fact, my lord, the earlier notification prior to disposal of this petition and the subsequent notification which my learned friend has said, my lord,
perhaps
I have already brought on record the contents of the notification is same. Purpose of constitution of the committee is same. I have brought on record, my lord.
Let us see.
My lord, kindly take up the next item, my lord. Item number 40, contempt number 98. My affidavit in reply, my lord. And the page, running page, Malad 57, the earlier notification. That is prior to disposal of this writ petition. On consequent of court order dated so and so. And the next notification, Malad, can we see page 55? Constituted committee with the following members to examine the alleged irregularities in distribution of gazetted relief fund in the Solo Mankaso district. The same contents is there is also. Constitute the committee with the following members to examine the reports of the inquiry report so and so. Alleged irregularities in distribution of the gazetted of relief.
Okay. On 6/3/2026. This is repeating the same.
Well, therefore, my lord, principal kindly appreciate, my lord. How can I improve? How can I improve, my lord?
R. Islam, learned counsel for the petitioner,
All the
petitioners. Mr. R. Borpuzari, you are for?
My lord, for R1, my lord, in all the matters, respondent number 1.
R. Borpuzari, learned counsel for the respondent number 1. Who else? Mr. D. Nath, learned counsel for the respondent number 2. Close to. On 6/3/2026, when these cases were listed, the following order was passed. And to list the cases again on 11/3/2006. Para 2 para 6. This paragraph 5 quotation is from which paragraph? Mr. Affidavit of Opposition Respondent number 1.
Yes, my lord, we had.
Which paragraph? I have quoted, right?
Yes, my lord.
Okay. From the materials on record, it has emerged that after submission of the 2 inquiry reports, dated 16/9/2017 and 4/2/2022 and dated, a committee was constituted with the following members and the term of reference by the notification dated 24/6/2023. Pura quote video, 47, page 47. Subsequent to the orders, orders dated 22/5/2024, whereby the writ petitions were disposed of, the respondent number 1 another committee was constituted with the following members and the term of reference. Page 55, a second contempt case 98 or page 55. Para. On comparison of the term of reference in the two notifications dated 24/6/2023 and 4/9/2025, comma, the court, it is not within the court does not find, court does not privacy find any dissimilarity in the terms of reference of the two committees. Full stop. The first committee constituted by notification dated 24/6/2023 submitted a report recording its findings. It was thereafter the petitions were disposed of. Full stop. It is not within the comprehension of this court as to why the second committee by notification dated 4/9/2025 with the same term of reference has been constituted. Full stop. Full stop. There is no discernible steps, para. No discernible steps seem to have been taken for implementation of the orders dated 22/4/2025 till date. Full stop. There was no application. Within what time it was?
Within 3 months. With the
No
consensus of the-
application was ever filed by any of the respondents seeking extension of the time period for implementation of the orders. Full stop. No appeal has been preferred to assail the orders dated 22/5/2024. Full stop. Para. Mr. Borpujari, learned counsel appearing for a respondent number 1 has submitted on the basis of written instructions received from the respondent number 1, that the final calculation of the admissible amount to be paid to the vendors have been completed and is under process of due approval for release of funds following financial norms. Like release of budget to the DC/DDO concerned, who will in turn prepare bills through Treasury to release the individual vendors, to release the amount to the individual vendors. Para. Mr. Bobusai, the instruction you placed from time to time have clearly made out a case for writ appeal, not to sit in the judgment of the court. If it is inflated, something, whatever grounds, you should have preferred the appeal to get the order set aside. So why you have kept waiting?
Because what has happened perhaps, my lord?
Uh-huh.
What has happened perhaps, my lord, in the writ court judgment, my lord, in the affidavit that was filed, in the affidavit, my lord, that first committee's report was enclosed, my lord, which lordship has just now seen, of the year 2023. And thereafter, an instruction was furnished by the department, which said, my lord, that the bills will be clear. Quantum was not specified. Perhaps for that matter, my lord, department was also under the impression. Of course, that will be too late in the day, my lord, to make such a submission. But that appears to be the solitary reason. That appears to be the solitary reason.
From the above fact situation, comma, the above obtaining fact situation is clearly suggestive of the fact that there is no real intent on the part of the alleged contemners. To comply with the orders dated so and so in the right earnest. Para. The Honorable Supreme Court in Israel Ahmed Khan versus Amarnath Prasad and others, 2026 INSC 209, has observed that the parties who are allegedly in contempt is not to be given an unduly long rope. The formation of a second committee after the orders dated so and so appears to be an inexcusable justification for non-compliance. Full stop. Para. Noting, having considered the above facts circumstances, comma, a last opportunity is given to a last opportunity of 1 month is given to the respondents to comply with the order. And a compliance affidavit should be filed to that effect. Lays the case on switch. Otherwise, in the event.
The second.
In the event, after VU detail, in the event. No. If the order is not complied with. If the order is not complied with, our orders dated 22/5/2024, right?
Yes.
Are not complied with, the court will proceed for further consideration. And to pass orders, we need a purview of contempt jurisdiction. So basically to frame charges.
Yes, absolutely, my lord. I cannot forcefully defend, my lord.
27th April.
Yes.
27th.
I have seen long rope is always given just to let us
Yes, yes, my lord.
comply with the orders.
Absolutely, my lord. We have to go down, my lord.
Or subject to appeal, definitely.
That is
It is
always
not that
open.
you sit over the matter.
Yes. Correct, Lordship is correct. Absolutely
Constituting
correct.
committees after committee,
Yes, yes, yes.
having good location and good lunch.
43.
I am so obliged.
May I please, Lordship?
Mr.
S.A. Islam. Lordship,
Petitioner
services complete, sir, Lordship.
Petitioner is present.
But Lordship, this matter is wrongly listed today. Mention memo. Case number-
Peruse the office note dated 9/3/2025. Yes, what you are saying?
This matter wrongly listed today, Lordship. Mention
What
memo.
listed?
Mention memo case number is, our case number is different, Lordship. We are not mentioning in this case.
Mr.
S.A. Islam.
S.A. Islam Learned Counsel petition submitted that the contempt petition he had mentioned for listing was contempt case number 336/2023. Full stop. However, instead of contempt case number so and so, the contempt case C number 336/2025 has been listed. He has sought office to examine the office to peruse the concerned mentioned memo and thereafter release the appropriate case on students.
Mass of Lordship.
27 March, 27/03.
Oh, news.
Item 44.
Please, your Lordship. Lordship, we have taken steps on 19/12/2025 as the office of reveals that service is awaited.
Miss
Pikash.
P. Kashyap, Learned Counsel for the petitioner. Peruse the office note dated so and so 6/3/2026. Await further service reports. Release the case after 2 weeks.
45.
Lordship. Madam, I may be allowed to take step justice service on letter number 2, madam.
No justice service content case. Unserved notice. Addressee left.
2, madam. Last
Two.
portion, madam. Last portion. Last paragraph.
Unserved notice.
Till date, no.
What about response number 1?
1, she left, madam. She left the office.
Okay, Mr. S.P. House, Learned Counsel for the petitioner has prayed for another opportunity to take steps for service of notice upon the response number 2 at his or her
His
correct and proper address. The prayer is allowed. The steps be taken with by speed post within 2 working days from today. Release the case after 4 weeks.
47.
Make please, Lordship. Notice not dated 11/3, Lordship.
Mr.
R. Islam, Lordships. This is complete, Lordship.
And Mr. R. Islam, Learned Counsel for the petition. Ms. Thapa, P. Thapa, Learned Standing Counsel. Learned Counsel on behalf of Mr. S. Dr. Learned Standing Counsel, Panchayat and Rural Development Department, 1, 2, 4, 6, and 7. And Ms. Evdas so-and-so, response number 3. peruse the office note dated 6/3/2026, release the case before the Law Jima Court for a report as legal service or notice under respond number 5 and 8. And thereafter to list the case on so and so with the report.
Item 48.
Yes, please be Sharma. Yes.
If some more time is required to complete the dusty service, Lordship.
Justice have been ordered.
Lordship.
No affidavit has been received. Okay, Miss P. Sharma, petitioner, M. Bhuya, United Counsel on behalf of B. Gogoi. Yes.
I am appearing for a response number 4, man.
Response number 4.
4 in both the case as well, 48 and 49.
Good enough. Not required.
Lordship.
Okay, I heard Miss P. Sharma, Learned Counsel for the petition, Miss M. Bhuya, Learned Counsel on behalf of Mr. B. Gogoi, Learned Additional Advocate General Assam for the response number 1, 2, and 3. Mr.
As per us,
As per us, Learned Counsel has submitted that he has entered appearance on behalf of the response number 4. Full stop. You need any time? By filing Okaranama. Full stop.
Regarding this matter.
You'll sit tight?
No,
We can proceed with the repetition.
No, we can proceed, Lordship.
We can proceed without any affidavit from other side.
I will have to file Okaranama. For that, some time may be given, my lord.
You have not filed a new
No, my lord. I have received today, my lord. I will be filing it today. Tomorrow.
He has submitted that he has instruction to appear on behalf of the respondent number 4, and the Okaranama will be filed within 2 days' time. Full stop. Both Mr. Bhuya and Mr. Parahar have prayed for and are granted. How much time you need? 1 week. 1 week.
Lordship, regarding this matter, there are some instructions which Mr. B. Gogoi has regarding this, which are really pertinent to the two tenders which have been challenged here. Lordship, that instruction is with him. It's not with me. Lordship, he's on legs in court number 10 right now. So.
Tell me what time you want?
In that case, Lordship, if Lordship permits, let it be after a week only. I will provide those instructions.
You have sought for. Yes, here comes Mr. Gogoi. Site visit, something like that. Respondent number 4 has appeared. So all respondents are represented.
Lordship.
What to do? Mr. Bhuya said you have received instruction already. Some site
Oh,
visit.
this one. KK Enterprise. My instructions are awaited, my lord. Yes.
Instructions are
Awaited,
awaited. How
yes.
much time you need?
So, my lord, say another 10 days, my lord.
10 days. Have both prayed for. And are granted 10 days time to obtain the necessary instructions and to file the counter affidavits,
Yes.
if so advised.
My lord.
Full
In
stop.
time maybe control.
Huh?
In time maybe.
Wait, madam.
Lordship.
Wait. I am still having with patients at 5 o'clock. Be patient. Release the case on so and so.
Lord,
The
give
interim
a
order
date,
passed
my
earlier shall continue till the next day.
5702.
Same in item 49. You
My lord.
the hearing stands adjourned. Mr. Das, why you are waiting?
Item 50 alone.
Huh? That is what hearing stands adjourned. Not in a position. The petitioner counsel is available.
Nobody is appealing, madam.
Oh, why, Mr. Das, why you have kept Mr. Das waiting till 5 o'clock? You should have said that.
Only formal parties, madam.
Nobody is there. There is no representation on behalf of the petitioner today on call. Mr. N.C. Das, senior counsel, assisted by Mr. A. Das, learned counsel for the petitioner, and Ms. U. Das, learned additional senior government advocate for the state respondents are present. In view of non-representation on behalf of the petitioner today on call, let the case be listed on so and so. After review.
2804.
Published.